Welcome back. We are on the record, and the first docket item is docket number 2023-011, cause number 132-13. And this matter has been continued to the August 26, 2023 board hearing. But I believe we have someone that would like to comment on this. Mr. Mayo?
Yeah, Chairman, members of the board, Mitch Mayo of Lear & Lear on behalf of OVINTIV USA, Inc. I just wanted to make a couple comments. One, clarifying for the record to make sure that the record reflects what's happened, and two, just to kind of address the way these hearings progress in general. First of all, a quick clarification. I believe you said into the record mistakenly it was continued to the August 26th. I think you meant the April 26th board hearing.
Did I say? Yes, April 26th.
To the extent I heard it incorrectly, forgive me, but just to clarify, this was continued by the hearing examiner to the April 26th. As a point of order for clarifying the record, there isn't a written order in place continuing that. There's been an order orally entered at the hearing examiner hearing and now acknowledged by the board. But if the board would like, I'm happy to prepare an order for the board's signature. I just wanted to see if that was something that was necessary as part of this record.
I don't believe that's necessary.
Thank you. And second of all, I'd just like to apologize in part for the board having to hear this matter today. When this was filed initially, it was filed seeking a hearing examiner hearing because the OVINTIV and myself believed, based on past experience, this was going to be uncontested and involve relatively novel issues, or well-trod issues, something the hearing examiner could handle quite easily. It wasn't until moments before the hearing, the night before the hearing, that we learned that it was going to be contested. And so I just wanted to apologize, but also point out the kind of trickle effect that happens from, deadlines matter in these cases, and all of us have had times where we've been hit with things where we can't meet deadlines. The fact of the matter is, the late responses filed by the division in this matter and in the companion matters not only delay this hearing, because we had to continue this because we didn't have the opportunity to really digest what had been provided, what the objection was, and how we were going to navigate it. So it not only complicates this hearing by not being able to approve an order entered by a hearing examiner as duly ordered, but it also complicates next month's hearing when this matter will be continued and added to what I imagine will already be a full docket. And so just by way of combined apology and reminder to the board, this was in good faith intended to be uncontested and was assumed to be an uncontested matter after the response deadline passed. But we are here. So I just wanted to apologize that it happened that way. We will try in the future to do our best to keep hearing examiner hearings focused on uncontested matters and bring anything we believe may be contested before the board. So with that clarification, I just wanted to move to continue, and I'll see you in April.
Thank you for that context. Much appreciated. Division, do you have any comments on this issue you'd like to share with us?
The division has stipulated to continue that matter, and I think it should happen. I'm happy to address the timeliness of the division's objections now if you'd like, but I think you are about to hear argument on that very issue next. It's up to you when you'd like to hear that.
I can wait 5 minutes.
Okay.
Thank you. All right, I believe we can move on to the next item, number 2. This is docket number 2023-013, cause number 132-15, in the matter of the request for agency action of OVINTIV USA, Inc. for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting owners in the Knoll, Utah 13-10, 4-2-15-22-5H well in the drilling unit established for production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Formations. I would now ask for appearance of counsel.
Fred McDonald of counsel with Lear & Lear with my co-counsel Mitch Mayo of Lear & Lear on behalf of OVINTIV USA, Inc.
Elizabeth Harris with the an Assistant Attorney General for the Division of, Oil, Gas, and Mining. Thank you.
And I believe this was also had a hearing examiner?
Yes, I'll give a few brief introductions on this before I turn it over to my counselor, Trevor Guru.
All right.
John, can you turn your mic on?
Yeah, I just did.
Okay, thank you.
You need me to state that again, or?
Yes, please.
Okay. Yes, I'm the hearing examiner, and I had a Representative Trevor Guru of the Attorney General's office.
Okay. This is a lot of parties all at once. Is anyone concerned if we hear from the hearing examiner first to kind of get the broad framework of what he listened to and the conclusions from that?
That's fine, Mr. Chairman. I believe that's what counsel for the division and I have agreed upon.
Okay. Thank you very much.
Okay.
Over to you.
Thank you. Good morning, Chairman Borden and members of the board. My name is John Rogers, and I'm an environmental manager with the division, and I've been asked to act as a hearing examiner in the following matter. Docket number 2023-013, cause number 132-15. Mr. Borden, you read into what this request for agency action was, so I won't repeat that, but I'll go on. The Utah Board of Oil, Gas, and Mining issued an order on February 21st, 2023, referring this matter to a hearing examiner. The board issued an order on March 10th, 2023, allowing the petitioner's OVINTIV witnesses to participate in the hearing before me electronically. The hearing was held Tuesday, March 14th, 2023, with an anchor location in Department of Natural Resources building in Salt Lake City, and participation by OVINTIV witnesses from the Woodlands, Texas. Elizabeth Harris, Assistant Attorney General, appeared as attorney for the division. Dustin Doucette, Engineering Manager for the division, was present and asked questions of OVINTIV. Frederick McDonald of counsel Lear & Lear appeared as attorney for OVINTIV. OVINTIV's witnesses were present and participated electronically. Mr. Peter Burns, Senior Land Negotiator, and Mr. Kendall Brown, Manager, Uinta Reservoir Engineering. I recognize both as expert witnesses in their area, and there is no objection by the division. At the commencement of the hearing, Mr. McDonald advised that since the filing of its request for agency action on February 10th, there were other parties that now were going to be considered voluntarily pulled. This was the interest of Mac Pearson Trustee, Mac Pearson Revocable Trust, and Hagen Pearson of the Hagen Pearson Revocable Trust. The estate of Chad Evans and Lindsay Noble has all been considered interests and are interests and voluntarily pulled. Therefore, OVINTIV no longer sought to have them compulsory pulled, and their respective interests amended in RAA accordingly. OVINTIV provided evidence that all remaining unleased oil and gas mineral interest owners were either sent a notice of opportunity to participate or were provided notice by publication pursuant to board orders granting corrected motion for service by publication. OVINTIV also provided evidence that the risk involved in drilling the subject well justified the 300% compensation penalty. OVINTIV further provided evidence that the proposed JOA contains terms that are just and reasonable to govern the relationship of the OVINTIV and as the operator and unleased parties OVINTIV seeks to compulsory pull. The division did not file a response to the request for agency action, but at the hearing raised objection concerning the owners who received OVINTIV's notice of opportunity to participate. Specifically, the division objected to OVINTIV's removing or failing to include details which would have informed the owners of their proportionate share and their estimated proportionate costs drilling of the well. If the owner should choose to participate. The division argued that withholding that information from the notice of opportunity to participate prevented mineral interest owners from the ability to make a fully informed decision, so imposing a penalty on them would be improper. OVINTIV argued that the regulation does not require an operator to provide that information in a notice of opportunity to participate. I heard arguments and explanations from both the division and OVINTIV on the issue. The division expressed had no objection to the other relief requested in the request for agency action. No other parties filed a response to the request for agency action, and no other party appeared to participate at the hearing. As a consequence of their failure to timely file a response and appear at the hearing after the proper notice to them, Mr. McDonald made an oral motion that the commencement of the hearing to declare the compulsory pulled party in default pursuant to Utah Code, Administrative Code. However, the hearing examiner deferred the ruling on that motion pending a resolution of the division's objection. I recommend that the board compulsorily pull the interest in the unlocatables and Bryn and Brigham, who received notice by publication. Further, the board should adopt the terms of the JOA to govern the relationship of OVINTIV as an operator and the parties who receive notice by publication as non-operators. Lastly, the board should impose a 300% risk compensation penalty against those parties who receive notice by publication. I recommend the board find as a matter of fact that the remaining mineral interest owners receive a notice of opportunity to participate from OVINTIV. The board will need to determine if the notice of legally sufficient to impose the compensation penalty, and I have no opinion on that issue. At the time, I listened to both arguments and believe the matter of this importance should be decided by the board. In fact, a similar matter was to be heard the next day, and the petitioner asked for that matter to be continued. We just heard from Mr. Mitch Mayo concerning that. So going forward, I think the situation now is to determine whether there is proper notice and whether the penalty should be imposed. So at this time, I'll take any questions or turn the time back to you, Chairman Board.
Board, are there any questions for the hearing examiner? Thank you for that synopsis. I think that's really helpful. I believe we now need to go to the matter at hand. Mr. McDonald, over to you.
Thank you, Chairman Borden. At the commencement of this, I would like to move to strike the division's objection and the division's brief for untimeliness. Again, as the background was, the responses, including by regulation, the division's responses to the request for agency action were due on March 8th, 2023. Having received none, that's when we filed for the electronic participation, believing that this matter was uncontested, as we had thought when we filed the request for agency action. At 4:30 p.m. on Monday, March 13th, which is the evening before the hearing was scheduled, I received a phone call from the division's counsel indicating that they might object to the legal adequacy of the notice of opportunity to participate that was sent out. When the hearing commenced, that objection, or we went through the entire hearing, and then the division, after our presentation in chief, then raised that objection, to which then argument had to be made off the cuff, without the opportunity to brief or consider that at all. After the hearing, it was stipulated between counsel for the board and counsel for the division and myself that we would provide supplemental briefing to the board, hoping that would help the board make this decision, and that was to be submitted by noon on Monday, March 20th. At 11:15, I have received a call from the division's counsel stating that she would need some more time, but that I would have it by that afternoon. At 5:39 last night, I received the brief from the division. We have been not afforded the opportunity to review that, whereas the division's counsel had the benefit of my brief for at least a day and a half. And again, I do not have the opportunity to review any of the case law she cites or some of the other arguments that she's making. And for those reasons, we ask that it be stricken as untimely, both the objection and the brief. Thank you.
Division, would you like to respond?
Thank you. Mr. McDonald, first let me say, has been very gracious throughout these proceedings, and I appreciate his professionalism in these proceedings. I think Mr. McDonald has accurately laid out the time frame of what occurred. The division, as it understands its role, is to advise the board in these proceedings. We are not a standard adversarial party to these operators that are coming in and seeking relief from the board. The statute that dictates what the division's duties are, 40-6-16, outlines the division's duties as evaluating and reviewing prior to a hearing the evidence that was submitted to be presented to the board. The division then is also tasked with advising the board on the information and evidence that is received. The division in raising these objections is raising it based on the evidence that was provided. We are not contesting the matter directly. We are saying the evidence appears to be insufficient and providing that advice to the board based on our review and evaluation. If we were an adversarial party objecting to the matter on its face, those timelines might be more important. The rule that talks about when responses are due specifically states that the board can consider anything that it deems that you have the discretion to consider what you need. So if the division's advice and evaluation of this evidence is something that would be helpful to the board, the division is very open to offering it and providing it. If it is not going to be helpful in this matter, then we won't need to present it. Oh, and I'm sorry. On the mea culpa on the briefing. Mr. McDonald, as I have said, has been very gracious, and when we did raise this issue at the board hearing, we spoke with board's counsel and talked about the idea of presenting some briefing to assist the board in navigating this situation. We did agree to a noon deadline, and unfortunately, I was ill over the weekend. This required working over the weekend, given the short notice before the board hearing, and I was ill and was unable to do that. I did continue to do the brief to have it available for your assistance if it is helpful. I don't believe that there is any prejudice, given that there was not any reply briefing required, and I actually did not see Mr. McDonald's brief until mine had already been filed. So I don't believe there's prejudice, but again, that is up to the board, and it was, I will acknowledge, given my illness, it was not the time that we had agreed it would be filed. Thank you.
Thank you. Mr. McDonald, back to you.
Thank you, Mr. Chairman. To address, if the board looks at its rules, the division is named as a party and is responsible for filing objections by the same deadline, which in this case was March 8th. It doesn't matter whether it's adverse or not. If it has a response, it's due then. Also, as far as the position that's taken, this board has heard several matters from OVINTIV for compulsory pooling over the past year and a half, and this issue has not once been raised by the division. And for those reasons, to do it at the last minute and to, again, provide a brief at 5:30 last night, which, how am I supposed to respond to the case law and the arguments that are made, particularly if they're citing to other state regulations in that time period? We do believe it was prejudiced. We believe the division had the opportunity to make its objection. It has not done that timely. We had the opportunity to provide the brief, and I'm sympathetic to Ms. Harris as being sick, which is why I said, okay, if you haven't Monday, that's fine. That still gives me another day to look at it. So for these reasons, again, that's why we are asking the board to strike both the objection and her brief. Thank you.
If I can just add something quickly, I think there's a balancing that the board needs to take place, because the division does wear two different hats. It's a party, and it's held to party obligations, and it's a technical advisor as well. And similar to the way a named respondent company would be. And in that situation, if they failed to meet the response deadline and didn't provide any good cause for why they should be allowed to file untimely, they would still be allowed to show up here and offer public comment, but this board would consider it to be public comment, not an opposition. And so I think that's the nuance that maybe needs to be balanced when it comes to the division. It's every case they are both a party and a technical advisor, but a party has strict rules that it has to comply with. And to object formally, as was done in this case and affected 3 simultaneous matters, requires compliance with the rules. That's all I'd add.
Thank you, Mr. Mayo. I believe we are going to retire briefly for a consultation on this matter as a board. So we will return as rapidly as we can, and I thank you for your patience. Thank you. We are back on the record. I believe we will start with Mr. Moon needs to make a statement.
Yes, my family has interest in this drilling unit that we're talking about here, so I need to disclose that, and would state that if it's not objected to, I will participate but not vote in this matter.
No objection.
Can you clarify the interest? Are you a leased party or are you a consenting owner?
Yes, a leased party.
Okay,
Yeah.
then no objection. Thank you.
All right, we had some good discussions. This is a bit of a Gordian knot, but I'm prepared to make a procedural determination. Mr. McDonald, we are denying your request to strike the division's objection in this matter. We really want to hear all sides to make the most fair and informed decision we can. However, we do sustain the request to deny the brief which was written and submitted after the close of business hours yesterday. And I do realize there's many mitigating circumstances, but you know, I would counsel that the division try to meet deadlines, and I realize there's some things that we've all been sick and been unable to meet deadlines in the past, but we all know how important those deadlines are. So. That is our determination, and it's. Oh, and Julianne, can you strike that submittal from the division from yesterday from the record? Okay. I guess it's over to you, Mr. McDonald.
Thank you, Mr. Chairman. On our position regarding the legal adequacy of the notice to participate that OVINTIV sends out and was admitted into evidence before the hearing examiner, there's really not a lot I'm going to be able to add to the brief that we did submit timely. I think we outlined very succinctly why we believe that the notice is legally sufficient. I will hit on a couple of points. First of all, the language is clear and unambiguous, okay? The key element here that the board needs to take away is you're given the opportunity to participate in a well. You can either participate as a working interest owner in the well, or you can lease, or you can decide not to do that and be compulsory pooled. If you decide to participate in the well, you are responsible for your proportionate share of that interest, whatever it may be. And the reason we say this is the regulation is, as Mr. Moon knows, because I know he sat through the 2 years we went through the rulemaking on this, there were specific things that are set forth in that rule that talk about what you have to include as part of that notice, okay? Nowhere in that regulation does it say you have to specify what the owner's specific proportional interest is. And there's a reason for that, okay? Most of the time, you don't know. If there's a title opinion and there's a title dispute, or the title examiner is wrong, if you put down you own 1%, and therefore on a $7 million well you own $70,000, okay? If it turns out you own 10%, all of a sudden you're still responsible for $700,000 if you want to participate in the well. It doesn't matter. It's your proportionate share of the well. That's supported also by the statute, which talks in terms of consent to the drilling of a well or refuses to pay your proportionate share of costs. Okay? It's also supported by the fact that one of the elements that's listed there is that you have to include an AFE. If you look at the regulatory definition of an AFE, it says the total cost of the well. It doesn't say an owner's proportionate share. And the listing of the AFE within the regulation of the notice to participate doesn't say an AFE specifying the proportionate share of the owner. And it's because of these reasons we said of the uncertainty of if, like again, if you misstate what the interest is, does that invalidate the notice? The division's whole point is, well, you have to be informed to make a decision, okay? How can you be informed with the decision-making on that at all with that interest if it's wrong? And the also point that we try to make here is that there's got to be some responsibility on behalf of an owner to know what they own. And if they don't know, why don't they ask? It's right in there that if you have questions, ask. OVINTIV's address is on there. There's phone numbers. There's contact information. If you are going to make the decision as an unleased owner out in the basin that I want to participate as a working interest owner in a well, don't you think you should be sophisticated enough to know what you're getting into and ask questions? That's the reason why the regulation was written what it was. It doesn't specify it. And to say that, well, this operator does that, that's not an appropriate argument either, because they may take a form from a state that does require that kind of information and take on whatever liability. It doesn't matter. The regulatory requirement is that you have to submit a notice stating that you have an opportunity to participate in a well for your proportionate share. And the reason the reading in that is whatever it may be, or you're not. That's what's required. And then all the listing of all the important information that we went through to say this is what you need to have for an informed decision does not say that you have to specify what that interest is. And notwithstanding any of all of this, all of these parties that we're talking about here received the notice, didn't object to the JOA, didn't do anything within the 30-day period that's required under the statute, didn't initiate its own board action to impose a JOA that would have their specified interest or any objection, didn't object to a request for agency action, which the division clearly acknowledges was proper, and stating that you're going to be deemed a compulsory pooled party and imposed with a 300% risk assessment. None of them responded. That's a waiver. That's a waiver. And they should be declared as default. So even aside from all the issue, which we totally believe the regulation doesn't require, these parties waived it by not responding. So we don't understand the nature of the objection, and that's what we would do. Important point that I want to point out here as far as the obligation of a party to take on something here. The board, you may recall, some of you may recall the Haggerty case that came in front of the board. This involved an owner who was given an opportunity to participate in a federal unit, join a unit. Nothing about wells, anything like that. And it came in front of the board. The board felt that that was sufficient notice at the time. And what happened is the owner then took that up on appeal. And the Supreme Court said, well, look, you can't just say it's a federal unit. The statute requires notice about the opportunity to participate in a well. And if you don't identify the well, then that's insufficient notice. That's what the ruling is in the Haggerty case, okay? And the other part of that was 7 years later, the party came in to seek spacing and wanted to have it retroactive back to date of first production. And the Supreme Court denied that, and here's what they stated. Like a good law, like a good parent, does nothing for a person that he or she can't do independently. And it's not good law to cure one inequity by creating another. If you say that these notices are improper, then you're making the operators have to go back out, do the title at their own expense, notify everybody, and then have an election for a well that they assumed all the risk a while back. And so now they can come in at 100%. That is inequitable. The owner had a responsibility at a minimum, if they wanted to participate, to contact the operator and get the information, which the testimony that Mr. Burns gave in front of the hearing examiner specifically stated OVINTIV's policy is to answer those questions, including stating what they believe, not representing or warranting what the owner has, but what they believe may be the owner's proportionate share. So there's an obligation. You can't just make it all on the operator and everything else, especially given the regulation. Your job is to interpret that regulation as it's written, not reading into it things that the division now thinks have to be a part of it. So with that, that would conclude my argument regarding this and why these notices are proper. And even for some reason, if you don't, All these parties have waived that by not responding either to the notices or, more importantly, the request for agency action when they have all these other remedies that they could have followed and they didn't. Thank you. I would like to turn my time to Mr. Mayo if he has any additional comments.
Thank you. Just one quick addition to that. You know, if the board, in order for the board to determine that these notices were improper, the board has to make a couple determinations. It has to decide that there are implicit requirements within the regs that aren't spelled out. And in doing that, the board has to understand that that affords very little regulatory certainty for operators, and it also opens up future board hearings to collateral attacks from anyone saying, well, in addition to this piece of information, implicit in this is that I'd like to know my potential rate of return if I'm going to make an investment like this. Implicit is I'd like to know how quickly you expect this well to pay out. Or implicit in making a fully informed decision is knowing what your well results are from off lease, right? Those are all really important pieces of information, but they're not in the regs. And so if the board gets hung up on this, I'd like to remind it that the key is reading the regulation. And I think we can all acknowledge these two requirements that the division is putting forward are not written into the regulation. And so in order to determine these notices are improper, you have to acknowledge that there are implicit requirements and an inexhaustive list, and we have to prepare for the regulatory uncertainty that comes from that. And with that, I'd rest.
Board, any questions for? Yes, please proceed.
Mr. McDonald, I need to be educated on this. How does an operator address non-locatables or individuals that have deceased and their estate's not been probated yet, and later when people are probated, are those people, after a well's drilled, do you see them as subject to a 300% penalty?
Yes, under the way that the regulations were drafted, the situation is a lot of times you can't, and in order to have that imposed, the board has imposed the requirement to go out and provide a good faith affidavit stating all the efforts that were made to locate these parties before the board authorizes notice to those unlocatables through publication. It's the same process that you would follow if you were filing a quiet title action when you couldn't find the successors or the party who you're trying to quiet title against. You publish it in the notice in the paper that's there. The idea being that you have property there, you should be responsible in publication, and that's adequate to do that. So before the board even authorized notices to these unlocatables, you have to establish by good faith effort in an affidavit to the board that you've met and tried to find these parties. So that in that case, we find it appropriate that they're given an opportunity by publication, and if they don't respond, then they should be deemed non-consenting owners, the same situation. The risk is important because it rewards the companies that took the risk at the time.
So other than non-locatables, unprobated lands?
Unprobated lands are the problem because you don't know who the parties are. If you do, and I think you'll find if you go back and look at a lot of these situations, you will have the operators saying, look, we've got leases from parties who we think are the successors by virtue of heirship affidavits, obituary notices, research on FamilySearch.org. So they try to get everybody that they can, but there's always the chance, and I've had this come up several times with heirship affidavits, that they happen to admit a brother that they don't like, or they omit a stepbrother that has a legal right under the intestacy law to that portion of the interest. So that's the problem, is if you don't know about these parties and you've exercised good faith to do it, this is the only opportunity to get their interest pooled and taken care of. And remember that even if they're non-consenting owners, they still get the cost-free average weighted royalty. So it's not like they're being divested of their property.
Thank you.
I have a question.
Yes, Ms. Garrison.
If someone were to sign one of your letters to participate that you send out, and they subsequently get a bill for $10,000 and go, whoa, can they rescind their letter? or are they just on the hook for it?
They're on the hook for it. If you agree to participate in a well, if you're going to participate in a well, then you're responsible for your proportionate share of costs. And again, go to the AFE. The AFE sets forth what is a good faith estimate of what the total cost of drilling and completing the well is, okay? You could have all kinds of operational issues while you're drilling. You could be fishing and everything else. An AFE can go twice as much, 3 times as much. Now, if that person wants to say the operator was had gross negligence or some other standpoint in what they were doing that cost overrun, they have remedies that way. But when you sign an AFE, you are committing to pay your proportionate share, whatever that cost may be, and whatever your interest is. That's the whole point.
Mr. Moon.
Historically, Newfield and then OVINTIV included the owner's interest in this letter. When did that change and why?
I'm not at liberty to answer that, Mr. Moon. All I can tell you is that the regulation does not require the specificity of it. If people want to include it in it, more power to them. It may avoid the landman getting 150 questions afterwards about what it may be, but I can't answer that question. And again, I can speculate that if you look at some of the states that may require that requirement, they may be using the same AFE form and not making the changeover.
One important clarification is Newfield never operated under the existing pooling rules. So that would be the explanation for why Newfield did it that way. There weren't these rules.
Would it be okay if we ask your client to answer that?
Mr. Burns, since you were sworn into testimony, do you want to try and answer that, or Mr. Lear, who's also there? And do we need to swear him under oath again? Okay, at this time, then I would ask, Mr. Burns, are you going to answer this one?
I can, yes.
Okay, if you would swear in Mr. Burns as a witness. This is Peter Burns, who's the land negotiator and who was recognized as an expert in petroleum land management by the hearing examiner.
Mr. Burns, do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Burns, would you please answer Mr. Moon's question as to why Newfield or OVINTIV as a successor by name change may have included it prior but is no longer including it, the owner's specific interest?
Yes, we did switch to a different accounting system, which changed the AFE system. So that's why it may have been included prior to, but my recollection is that nowadays it is not included as a standard procedure.
In order to lease one of these unleased owners, assuming they're locatable, the non-locatables, you can't lease them because you don't know where they're at, but you do need to know the owner's interest, and in these letters, you have that option to lease. You just wait for them to call, though. It just seems efficient to put down, and even if you had to disclaim, you know, we don't know this may change. It just seems efficient to include that. Anything you can add so that we understand, you know, why that's not there, other than it's not absolutely required.
Yeah, I mean, we've fallen on that it's not required, but also, you know, as these letters are being sent out, we are either still waiting on a final title opinion to confirm interest, or there are curative items, curative requirements on the interest, and so a final interest has not yet been determined. And so, as opposed to sending out an incorrect or incomplete interest, we prefer to not put it in, have the owner call, and that way we can do some, you know, additional discussion with the owner, potentially get other curative that may help to confirm the interest that way.
Thank you.
How often do you hear from these people who get these letters? Is it fairly frequently, infrequently? Do people actually call and request information on their interest?
Yes, I mean, we are able to get some leases from these letters. We do not get often, many elections to participate, but we do get phone calls from owners asking about their interest.
I have one question also. Maybe I missed it, but when was the change actually made? Whether it was just due to changes in the accounting system used, but how recently did this occur?
I believe we switched. It was a process that we went through in 2021, and now we're fully integrated into the new accounting system.
So maybe a year ago here in Utah?
Yes, a little over a year ago.
Thank you. Any other?
Mr. Chairman?
Yes, Mr. Moon.
The division hasn't presented yet, but this question is more general. Have you had questions from owners complaining about this, that, hey, we don't know what to do because we don't have our, or is it just a gut feel that this notice is insufficient? Do you have some evidence that points to that?
I can answer, or if you'd like to put someone from the division under oath, we can have the division answer.
Both.
Okay.
Would that be better just to make sure you cover that when they're presenting, perhaps?
That'd be fine, too.
I can tell you, and well, whichever you would like. I can tell you, yes, the division gets calls. We have gotten calls recently on these types of issues.
Okay, if we can just wait a couple minutes, we'll hear it all. Okay.
Mr. Borton, if I may ask a redirect based on Ms. Garrison's question. Mr. Burns, I believe you testified to the hearing examiner, and one of the hearing examiner's findings was that OVINTIV, if a owner calls, you're willing to answer their questions, including trying to tell them what OVINTIV may think is their interest in the drilling unit. Is that correct?
Yes, it is.
Right. Thank you.
Thank you. I guess any more questions from the board? In that case, over to the division.
Thank you. I appreciate your time and I appreciate your consideration of these issues. The question before the board is very simple. It's did the notice, or basically has OVINTIV sufficiently complied with the regulatory requirements in order to have these owners deemed non-consenting owners and to impose the penalty? The definition of non-consenting owner, I'm just going to paraphrase it, but we can pull it up if you want to look at it, is basically an owner who, after receiving written notice of an election to participate, chooses not to participate in the well as a working interest owner. Do you have? We can pull it up and you can check my paraphrase. The key is that it is required that they get written notice before they can be deemed a non-consenting owner. Mr. McDonald talked about the Haggerty case that did deal with this definition, and the Haggerty court found that the written notice is a key requirement. These operators are the petitioners. They are the ones coming and seeking relief from the board, and they have to meet the requirements that are in place. So in that case, the court said you have to have sent written notice. Since the Haggerty case, the board took the opportunity to clarify exactly what notice is required, and that rule went into effect in 2020. It is the definition of a notice of an opportunity to participate. If we can pull that up. So a notice of opportunity to participate means the written notice of opportunity to participate in a well for oil and gas operations required under subsection 40-6-2, subsection 4, which is the definition of consenting owner, and 12, which is that non-consenting owner definition. So this is the written notice that we are requiring and that OVINTIV is required to send before in order to get this non-consent risk penalty. So it goes on to say that an offer must include an offer to lease if the owner is an unleased owner, and an offer for the owner to directly participate financially in proportion to the owner's interest in the drilling, testing, completion, equipping, and operation of the subject well. And then there are several other requirements that it must include as well that go into the well itself and what it's going to look like. And I think Mr. McDonald and Mr. Mayo have repeated that they don't believe that it's required and that the plain language there does not require them to include this sort of interest, and I would disagree. I think the plain language says you must present an offer for them to participate according to their proportionate share. Clearly, this rule has to be in a generic language, general generic language, because you can't specify in rule every single interest owners that we're going to see. But what the rule is doing is saying you are coming before the board and you are asking the board to put this penalty on these interest owners. It is interfering with their property interest, and it is a valid exercise of the police power. That has been litigated, but it is an interference with their property interest. And because of that, you have to meet certain requirements. I really like that Haggerty quote that Mr. McDonald quoted, that a good law is like a good parent, and it shouldn't do anything for a party that the party can't do for itself. And I would argue that is precisely what this rule is requiring. It's saying there are all of these parties out there that are not leased yet, that have the opportunity to participate, and they have the right to do it. And before you come to us and ask us to compulsory pool these parties, you need to go try and get them on board. You need to go try and get them leased, or you need to go give them notice that they can participate. And so what Mr. McDonald is asking you to do is to put that burden back on to either the board to compulsory pool these parties when they have not presented actual offers to do these things to these interest owners, or to put it on the interest owner themselves, who are not the parties in front of the board asking to create this drilling unit. They are not the ones asking to take another party's interest. If under statutory construction, kind of rules of construction, when you're interpreting statute, the very first thing you do is look at the plain language and decide what it says. And you don't just look at it in isolation, you look at it in the context of the entire statute. What is it trying to accomplish? In this case, they're trying to, the statute is accomplishing that the written notice is provided, that everybody is aware of what their opportunities are before they get forced pooling before the board and forced penalties. It makes sense to read that language in a way that would allow these interest owners to have the opportunity to participate so that they would have the information that they need. A few items. In particular about this well. This well these notices were sent out in October of 2022. Production on this well began in May of 2022. So the well had already been producing for approximately 4 to 5 months by the time these interest owners were even notified that they were going to be given this opportunity. So the operator had already determined that it was going to take the risk to drill this well. Before that, those costs were already fixed by the time these interest owners were given notice. Also fixed at that time were the actual costs. And so the AFE that was sent, it says it's an estimate of costs of what the actual drilling will be. But at the time that AFE was sent, they knew precisely what the drilling costs would be. So that was a fixed number. It was very easily calculatable for OVINTIV to provide that number to these interest owners. And arguably, since that well was producing, OVINTIV has to have some sort of idea what these interest owners own, because they have to hold that by the time they've come before the board, they've got the title work. They've got, they are the ones that are with the most knowledge about what that drilling unit is comprised of. It would be very, very difficult for an owner, based on what was provided, to figure out what exactly their interest would be. Because it's not just their ownership interest in a particular acre, it's their proportionate ownership interest in the entire drilling unit. This drilling unit is 1,306.59 acres. It isn't a regular, it isn't based on regular section lines, it's an irregular size. Takes into account certain plots and leaves out other plots. This is complicated technical information, and Mr. McDonald, under his argument, an owner would be required to first go out and figure out the title to all of those 1,306 acres to figure out what their percentage is. And so what that results in is you have these interest owners getting an AFE for a well that says this well is going to cost $6.7 million. And you can participate if you're willing to pay your share, or you can contact us and we'll talk about leasing. If you go in, and I will add, until the hearing, it wasn't in any of the evidence even what those ownership proportionate interests were anywhere. It wasn't contained in the exhibits. There was no way to know until there was testimony at the hearing as to what those proportionate interests were. If you go in and calculate what the proportionate interests are, it ranges from $194 to $25,716. And yet the notice that they got said this is a $6.7 million well. When I was reviewing these, the law and in preparation for this hearing, I took a hard look at how other states handle force pooling. And I really hope to find lots of states that made very clear that you had to conclude this. But what most states do is they have the same requirement that you have to give an offer before you can come seeking compulsory pooling or a penalty. But what those states do is that they include the language, it has to be a fair and reasonable offer. And if it's not a fair and reasonable offer, you can't get the penalty and you can't get compulsory pooling. So our statute or our rule does not include the terms fair and reasonable. However, I would argue that those terms are implied, that when the board passed that rule, they did not intend for it to be an unfair or an unreasonable offer. That would be absurd because there would be no point in having it in there other than to check a box. And I would argue that it is not fair or reasonable to send an interest owner a $6.7 million bill and ask and tell them that the only way they can participate is by binding themselves by signing a contract, signing the AFE, but never telling them how much it's going to cost them. That is not fair or reasonable. And to address Mr. Moon's question, if you would like me to now, if you are okay with placing Mr. Doucette under oath, we can have him answer Mr. Moon's question.
Yes, please proceed.
Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay.
I don't know.
Let's see. So, Mr. Doucette, I believe Board Member Moon asked, have the division received phone calls or heard from interest owners trying to figure out what their proportional interest is or having issues with this?
I guess in short, yes. I mean, we do get quite a few calls. A lot of them are on royalty interests and what that is and what that means to them. We get a lot of calls on when these board matters come up. You know, what does that mean to me type of thing. I know I specifically got a call back in probably early February. It wasn't in this matter, but it was a similar type of a setup where I had a gentleman asking me what his what the size of the acreage was, because that wasn't clear, because he had like a division order, I believe, in that case, that he was having a hard time getting to match up with what he thought it may be, and the acreage, I guess his percentage, which he was given in that division order, made it about 30 or 40 acres larger than what it appeared to be, so he was confused on that. So we do get maybe not as many questions on that aspect, but I think a lot of division personnel do, and I have personally gotten those questions as well.
So just thank you for that. But more specifically, have you had concerns expressed by owners that this offer to participate does not include my interest and therefore I don't know what to do? And I've reached out and perhaps haven't heard or haven't got a good answer from the operator. Have you had that?
I don't know if specifically on, and I can't speak for, the rest of the division. I mean, I don't recall if I've had a specific one in regards to the letter itself. Like I said, I've had several that may have been related to that, but not specifically on the letter, I don't think.
Okay, and then just to follow up to that, so OVINTIV and maybe other operators, I don't know, have not been including this for a year or two. When did this first become a concern to the division?
I mean, I didn't realize that there were any that had been submitted without it. No, I'm not saying there wasn't. When I was preparing for this matter, I specifically went back and looked, and I looked from 2016 to 2019, so maybe it was before the timing here. And in all of, I think about 12 matters, they all had that language included. And I think there were 5 or 6 different operators, including, I believe, OVINTIV in that case. I believe there was one OVINTIV had done a little over a year ago that also had it in their 2020 timeframe, I believe, maybe 2019, 2020, yeah. But this is the first time I noticed it, and it just kind of jumped out at me that wasn't included on this one. So I can't say that I recognized it prior if it was happening.
Thank you.
Sorry, and just one last point, and then I'm open for any questions. I do want to address the issue that by sending out this notice that includes a estimated proportionate interest, that somehow is binding the operator. I have 2 thoughts on that. First, as is clear in the AFE, it's an estimate. It is very possible to say that something is an estimate and that it has to be subject to final approval and certification that that is the accurate amount. Language can be very easily included that makes clear that that is not a binding offer until it is completely figured out. My other thought would be, as soon as the board issues a ruling and deems someone non-consenting, the rules require the operator to start presenting monthly accountings for the production that is occurring and their interest and the payoff amounts. So immediately, the operator is required to start accounting for, again, this exact interest. And so the information is there, and ignoring it at the front end does not serve any purpose. And with that, I'm happy to answer any questions. Thank you.
Yes, Ms. Sierra.
I just need some clarification. Assuming that Mr. McDonald's representation that the rules do not require specific proportionate ownership in the opportunity to participate. So maybe like in the business world, when you want to do business with somebody else, you kind of send a letter that says we want to do business, but you don't specify everything, and then you start the negotiation process. would it be similar to something along the lines where you send, the parties' intent to participate without the specificity of all the details, and then you begin to ask questions, get information on what it's going to mean to the other party? Is that not the opportunity, or is this letter offer to participate final, that you have to be that specific and not make any changes? I mean, that's kind of how I'm seeing the arguments here. But you did state a while ago that, a few moments ago, that you could, condition it, if you will, that it may change, the figures may change. But I'm just curious why the notice at first, you can't, if what Mr. McDonald says, it's not a requirement, why can't you just send something like what they sent without it being, inappropriate? I'm still trying to wrestle with that.
Sure. And for something that seems like it shouldn't be that hard to understand, it is incredibly opaque, it seems. So what the division is asking and what Mr. McDonald is asking the board to do is interpret that language. And so it is the definition of notice of opportunity to participate. You can read the language, and it's what do you believe that interpretation, how it should be interpreted. As to whether or not a party could be sent this letter and then have an opportunity to participate, I think there are two aspects. Under the way it is set up, under the rules and in that letter, a party, in order to be deemed a consenting party, has to sign the JOA that's included. They have to sign the AFE, that again is an estimate, not of exact costs. They have to sign and approve them and bind themselves to the contract and bind themselves to pay whatever expenses come up as a proportionate interest. And so basically, they are being bound under this contract without any of the specific information, if that isn't included. By presenting an offer in the notice of opportunity to participate, by saying, we believe your interest is X, and if you'd like, I can show you examples that every other operator that has done compulsory pooling matters since this rule went into place, how they do it, that is exactly what they say. We believe your interest is X. This is subject to final confirmation. If you would, your percentage would be $26,000 of this $6.8 million well. It is an offer to start the negotiations. Just because you make an offer doesn't mean it has to be accepted. There can be negotiations, there can be a counteroffer. The issue the division has is here there's not even an offer being made. There's a notice that they can participate and they're on the hook for all the costs, but there's no offer about what that participation would look like.
Board, any other questions? Mr. Moot.
So why is completely removing the penalty, why would that be an appropriate remedy to this versus just requesting the board consider requiring OVINTIV send these out with that ownership percentage? Why removing the penalty? Why is that? Why would that be the appropriate remedy?
Well, and the division was objecting to the imposition of the penalty. So we are not the petitioner. We're not coming and seeking relief. We are objecting that be imposed because we don't think the notice was sufficient. I think additional notice sent out to these parties is a great way to remedy this issue, that if it included their percentage and no one elected to participate at that point, I think the proper notice has been sent. The division's concern was under the Haggerty case and under the rules, to impose a penalty, you have to strictly comply with the requirements, and we don't feel like that requirement has been met, so we object to the penalty being imposed for that reason.
Any other questions from the board? Yes.
The division brought up that the timing of the drilling and completion of the well and when the offer was sent out. Could I direct a question to Mr. Burns on finding out why that was done? Would that be appropriate at this time or later? So, Mr. Burns, I'm wondering, drilling title opinion is what the well was drilled on. So why were these offers to lease for these parties sent out after the well was drilled and completed? Was that a factor because of division order title opinion that was done after the well?
Yes, that plays a role in just the sheer volume of unleased owners in some cases, and still continuing to do title to get confirmation. As the division order team is working to set up the deck for initial payment.
Do you find that in every well you drill that there's always a fair amount of unleased owners that you locate or you find out about after the well's drilled and completed?
Well, we often know, most at least around the time of drilling, but in a lot of these wells, there could be hundreds of unleased owners. So we are making every effort to try and locate them and deliver them notice, but that takes a monumental effort in some cases to locate everyone and do all this title work even after we have the title opinion.
So at some point in time, though, you as an operator make the decision that you're willing to take on a certain amount of risk yourself without having all the parties leased up.
Yes.
Thank you.
Any other questions from the board? Anything else from the division?
No, thank you.
Back to you, Mr. McDonald.
Thank you, Mr. Chairman. One thing you should understand if you haven't, and I know Mr. Moon and Ms. Garrison understand this, the title in the Uinta Basin is incredibly, incredibly complex. And so it's not always available at the time to determine these ownerships, which is one of the reasons, again, why there's the delay. The more important part about that delay is they still have to give the notice to participate at 100% if somebody wants to elect to it, already knowing that the well has been drilled and is producing. So it's actually a benefit to them at that point. The operator is actually waiving that in order to comply with the regulation if somebody elected to participate with that. So the risk was assumed, and here's even more of a benefit to this owner to make this election at this time. And if they still don't do it, then they've made the decision on it. So it's not like, that they're saying to take on the risk. They have to comply with that, and if somebody wants to come in at 100%, they actually get the benefit of the information about the well being producing. Couple of clarifications on what Ms. Harris stated. First of all, if you review the hearing transcript, you will see that Ms. Harris agreed and acknowledged that the notice parallels the exact language of the regulation. Parallels it. Okay? That's important. The reason is that if you try and interpret it the way that she's saying and start adding in requirements at this point, you're changing the rules in the middle of the game here. We went through a 2-year regulatory process. Look at the information that is required. We're talking about the horizontal, all this technical information that's important. And if somebody wants to be part of the well, that's the information that they need to have. Okay? And if they don't, they can ask questions. I believe your point, Ms. Sierra, is exactly right. That's exactly what the point is. They don't have to sign a JOA then and there. They have 30 days to talk about it and negotiate it. If they don't like the JOA terms, they still have to sign the AFE and then fight in front of the board about the terms of the JOA, as you well know in the last couple months, and what we're still going to have to deal with. So that is the negotiation. Going back to my original point, the first thing I said to you, it is an election to participate in the well, whatever your proportionate interest is. And if you don't know what you own, come ask. You heard Mr. Doucette's testimony, I didn't hear one single thing about, did the division direct somebody? Well, first of all, was there anybody that ever questioned the notice that was sent out based on the fact that it didn't include their proportionate interest? And secondly, doesn't the division say, well, have you talked to the operator? And you've heard the testimony from Mr. Burns, both in the hearing examiner and again today. It's OVINTIV's policy that when somebody calls, they talk about it. They negotiate. Those are the things. And I'm having a tough time understanding why an owner can sit back and do nothing here. Has absolutely no responsibility whatsoever to deal with their property. And it goes back to that Hagerty decision. Finally, if it's the board's feeling that this has to be done, then it's a policy decision, and if you want it included in the regulations, then you got to go back and put it in the regulations. You can't change the regulations today and read into something that's not there. These other states she's talking about, they specifically state that in there. And there's a reason why it wasn't included from the industry standpoint as part of this rulemaking. Finally, the last point I'm going to end on, and I'll turn it over to Mr. Mayo in case he has anything else to state, but there's no argument from Ms. Harris about the waiver. All of this notwithstanding, they got the notice, no response, no phone calls. They got the request for agency action. Did they file anything? No. Did they show up at the hearing? No. So if they weren't worried about it, then what's the problem here? I mean, they had numerous opportunities under our regulations to protect their interest, and they chose not to. Thank you. Mr. Mayo?
Yeah, not much to add, just to reiterate that the division's position is kind of changed throughout this, and that's okay because it's always, positions are subject to evaluation as you go along. But what essentially I've heard from the division as their position today is undoubtedly the rule requires this. And you have to remedy it by inserting this requirement that they provided. But it just needs to be an estimate. It doesn't matter if it's accurate, but it has to be in there, or else it's fatally flawed. So to me, I have a hard time getting there when the rule and the language is so clear. It says you must provide a notice of opportunity to participate. Unequivocally, that's done today. The question is whether that, implicit in that, is the percentage interest. No reason to beat a dead horse. But the point being, the rule is clear and unambiguous, and this board, acting as a court in Utah, is bound to interpret and apply Utah law. And one of those key provisions is, when doing statutory interpretation, you are required to look first and only at the plain language. And I think the plain language of this regulation is clear and unambiguous. And that's that if you provide a notice of opportunity to participate that is tied to your proportionate share, you have satisfied the notice requirements under the regs. And with that, I'm done.
Done? Would you like any last words?
Just two quick things. First, on the waiver issue, I did not address waiver because I don't believe this is a question of waiver. These parties are not coming in and requesting relief from the board. OVINTIV is coming in requesting relief from the board, and OVINTIV, in order to get that relief, must show that it has met the requirements. And the division's objection is that we don't believe that they have met those requirements, and so they are not entitled to the relief. That is a separate issue of whether or not these property owners should have come and made an objection to protect their interest. The second issue is, Mr. Mayo is exactly right. When interpreting language, you need to look at the statute and see the plain language of the rule or statute and see what it says. And if you can interpret it in more than one way, if there is a reasonable conclusion that it could be interpreted two different ways, that is an ambiguous statute. And I would argue this is ambiguous. I did concede at the hearing examiner proceeding. I think it's very obvious. They mirror the language that is in that rule. And yet they completely miss the point that the rule requires an actual offer according to their share. It is generic language to address the fact that there are so many you can't address them all in rule. And with that, I would close. Thank you very much for your time.
Board, are there any last questions before we deliberate about this? I believe we are going to retire and have some discussions about this very simple issue.
Could I be afforded an opportunity to make a brief public comment?
Does he have to say anything?
It's just public comment. You can say any objections, but it's just public comment.
Any objections?
Yes.
I'm sorry, can we have him say that into the mic so that we can get that online?
Thank you, Mr. Chairman. I wondered if I might be able to make a brief public comment on the matter that you've just been hearing.
Oh, you should identify yourself as well.
Anthony Hunter.
Any objections to?
Yes, Mr. Hunter and his clients are not parties to this, and if the board is even inclined to consider his comments, it should be given no evidentiary weight.
It is public comment. It doesn't have evidentiary weight.
I just want the objection on the record.
Okay. You may proceed.
Thank you, Mr. Chairman. As I was spectating back in the peanut gallery, a lot of things went through my mind as I was listening to this. The first one is that in my experience in not only Utah, but Kansas and North Dakota, a little bit in Colorado sometimes, but an authorization for expenditure needs to be a meaningful opportunity to decide what to do. Proportionate share tells the owner exactly what they think it's going to cost up front. As Ms. Harris pointed out, it's not really an offer if you don't know what the price tag is. It's an essential term of any contract. So you have to know not only the total amount the well is going to cost, but also your piece of it. I think Ms. Sierra, her question, you've got 30 days to figure this out. Without that number on the AFE, your clock's already running, and now you may have to play phone tag with the person that knows the answer. And that may be why the division gets the call. Someone's panicking, needing to find out what's going on. I don't understand this. The next thing is that you don't have the time or resources as an unleased owner to enter this world. Mr. McDonald would like to say, if you want to be sophisticated, well, why don't you know this stuff, or why don't you find this stuff out? Those letters go out to a whole bunch of range of different people. Maybe some of them are, old hands in the oil field out there in the basin. Some of them might be the children of those people and have no idea what was in Grandpa's safety deposit box. You're going to reach a variety of people, and their entry point into this is a letter out of the blue with the bottom line of $6.7 million. Good gracious, what do I do? And the clock's running. And the rules changed. The rules changed, and then OVINTIV's policy changed with it. The accounting system changed with it. And that's no basis for state action. It's not binding on them. They can change their policy next week. So they may change their policy to not answer that question anymore because the regulation, under their view, doesn't say they have to. So, and to Mr. Church's question that they take on a certain amount of risk, I would recommend to your reading a footnote in a filing dated April 17th, 2015, cause number 139-30, footnote number 26, where I spell out exactly why these types of things are a profit center. Because it costs money, and it's expensive and time consuming, as you heard the testimony, to determine these title problems. It's expensive and hard. And if we're talking a $194 interest rather than a $26,000 one, it just doesn't pay to figure out who those people are. It just doesn't. And so it makes a lot more sense to deem them non-locatable or non-consenting and collect a 300% penalty on it. All of a sudden, you're collecting more money than you would have owed to them had you figured out their title. So you collect back 3 times what it costs their proportionate share over the life of the well. And I want to address Ms. Harris's other point about reading some things into it. As I already stated, you've got to read into the AFE that it has to be your proportionate share because it's not a meaningful offer otherwise. I agree completely with her. But the statute itself says that pooling orders have to be just and reasonable. You don't have to pretend it's in the regulation. It's in the statute that pooling orders have to be just and reasonable. It's already there. And finally, I think just from a practitioner standpoint, a former title practitioner standpoint, I don't do title anymore, but when you've got a drilling order title opinion, it tells you, it adds up to 100%. You know what you're supposed to do with all of it. Some of those things are confusing. Suspend until you get some certain title curative. Pay out, but only after you get confirmation of this title transfer. You know, they're hard. They're very hard. But once that drilling order title, division order title opinion has come in, you know where all that money's supposed to go. And as Ms. Harris pointed out, they've got duties and obligations the second that that pooling order goes through to account for those non-consent penalties and the payout time to all those people. So to say that it's uncertain or confusing or we need more time, it's a little disingenuous because they have obligations under the statute right away once that pooling order goes through. And if they don't know by then, they maybe shouldn't be paying anybody just yet. And that concludes my public comment. Thank you.
All right, we are going to go off the record for deliberations, and
Should
we'll
we break
return.
for lunch, or? More than 5 minutes.
All right, and we shall break for lunch as well. Back at 1. And we'll have a working lunch, don't you fear.
We'll chew on this well.
Welcome back, everybody. We are on the record, and we are back on docket number 2023-013, cause number 132-15, and I believe I would like to entertain a motion.
Mr. Chairman, I'd like to make a motion that we approve the request as the relief is requested and recommended by the hearing examiner, Mr. Rogers.
I'll second that motion.
Any last comments from the board before we vote?
I would like to make an additional comment that I too found that it would have been very helpful to have more information on the notice that was given to the individuals that are being forced pooled as a clarity of offers to lease.
Any other board members? Before I vote, I also want to express a couple of thoughts. I do feel that the notifications provided by OVINTIV were legally sufficient, but I also feel that the notifications have been written in such a vague manner and provide insufficient information such that they might discourage participation by some interest owners, which makes me feel a little uncomfortable. Seeing no other comments by the board, all those in favor say aye.
Aye.
All those in favor say no. No, huh? Let the record show that vote was 3 yes and 1 no, huh? So the order is approved.
Mr. Chairman, a couple questions. First of all, so the board is ruling that this notice was legally sufficient, but with your commentary. Is that correct? Okay.
Correct.
Second is, did Mr. Walker participate in the vote or not?
He did not.
He did not.
Okay. Okay, so it's a 3-to-1 vote. Okay.
Yes.
Mr. Mayo has a question.
Yeah, just for my related matter, the brothers matter that was supposed to be held at a hearing examiner hearing on the 15th and is now continued to April 26th. What now? I'm assuming that notice, if it has the same, kind of emotional defects, is still legally sufficient, and we should move ahead at the April hearing. But if there's any clarification that's needed, obviously it'll save board and division time to get that on the record here.
You can talk to board counsel afterwards. I don't think I want to give any opinion right now. Thanks.
And could I just share my non-voting opinion? I concluded that it was legally sufficient, barely. More information would be helpful to owners. An offer to participate or lease, it's hard to gather in what's there that there's an offer. It's kind of contact us if you have questions. An offer to lease, there's other offers from Newfield and others where lease terms are spelled out and where ownerships are given and amounts. And so where I am is just saying, strongly encouraging that there be more information in those. But this does meet a minimum requirement to have notice.
May I ask, when you say this information, is it a matter of providing them their percentage of the interest in the drilling unit, or are you also asking that they spell out what their cost based on the estimate is? I mean, we need some clarification on this.
In my opinion, just look at what other companies have been doing. Because when those rules were written, I think there was an assumption, here's where we're at, and here's kind of some details. Standard practice was to include that, and so that's where I would be, is that's standard practice to do that.
Is it fair then to part of this is Mr. McDonald and I are here representing OVINTIV today, but we also appear before the board representing other operators and other interested parties at different times. And advising them is a big part of what we do, right? How to do what they do. Is it fair to say that the concerns the division has expressed, so that the board is now kind of expressing in its rejection of the division's position, is limited to percent of ownership and percent of cost? When we talk about additional information that would be helpful, is it fair to say that if Mr. McDonald and I, any other practitioners who are here, advise clients in the future, there is this list of specific information and the percent of ownership they own and their proportionate share of costs, is it safe to assume that's kind of where the additional requested information would end?
So I think we want to avoid going into specifics here, but I would advise you to just talk to board counsel and maybe have this conversation with them and maybe seek some clarity.
Well, except that the board is the policy here. So we have to get some consensus from you so we have the regulatory certainty. You're saying that this is legally sufficient, but we'd like to see this. And so what I think we're trying to say is industry saying, okay, board, if that's what you want, but we're also concerned that you're also opening the door that all of a sudden the next objection is, well, you didn't tell us what the log was, or you didn't tell us what the production history was.
Okay, how about this as an answer? What OVINTIV was doing a couple of years ago didn't raise any concerns.
Well, what they're currently didn't either until yesterday. Okay, but that's fine. If it's a matter of the percentage, the specific percentage, at least that gives us some clarification. The other question I have is procedurally, do you want me to prepare an order then for the board? Because adopting his hearing examiner left the question open of whether that was legally correct.
Yes, thank you for that.
Thank you.
Yes, please prepare an order.
And one clarification for my matter that's already been filed and is pending now on continuance. I'm assuming cases currently filed are grandfathered into this idea, as opposed to OVINTIV is now being instructed to essentially withdraw it, send new notices, wait 30 days, refile the same documents, and come back.
I think that would be unfair. So, yes.
Grandfathered in if currently filed.
Yes.
How about this? On the other two OVINTIV matters, the division will stipulate that it's not going to raise the objection, given the board's ruling. So
That seems sufficient clarity to implement. That's all we're trying to do, is implement what the board's putting in. Thank you.
For the record, we probably ought to make that stipulation as each matter is called.
Okay, are we done with that item? Thank you for your patience. So we're gonna rejig the agenda a little bit, because we do have a lot of people here who are only here for the discussion of cessation of annual reporting requirements and final determination of sunset provisions in pilot project spacing orders. Just for a little background, when I started on the board 8 years ago or so, horizontal drilling was not all that common. It was innovative in Utah, and so the pilot projects were initiated in the early days because of concerns about establishing maybe bad precedents or unforeseen consequences that cause trouble later on. And two key provisions common in those pilot projects was, one, that they weren't a permanent order. They had a sunset provision after a certain number of years. And two, was annual reporting on how the projects were going. We're now in a different time scale. It's a much more mature strategy using horizontal drilling in the basin, and so I think it's time to revisit this, and which is why we've invited you all here. How many people are prepared to speak to the board today on this issue? I just should get a feel. 1, 2, 3, 4, 5. Okay, and yes, Mr. Mayo?
Just a suggestion, maybe a more helpful question would be how many people are here to speak against the orders being approved? Because I would imagine there are a lot of people going to repeat their support for this.
Thank you, Mr. Mayor. We'll keep that in mind and we'll proceed. Okay. So I'm just going to call you up one at a time. Mr. Chicken, could you come up first? And I believe if you all find yourselves repeating each other on, then we'll assume the presentations get shorter and shorter. Can he sit?
Absolutely.
Has he got to go? Is that why I called him first?
And he's the one the most knowledgeable about this.
Okay. It appears to be up on our screen, huh?
Oh, we don't see it here, but everybody else can see it, yes?
Uh-huh.
There it is. Dun, dun, dun. Okay. I think we're good too. Can everyone hear me? Do I need to? I'm always bad with these. Sometimes, like, I put it really close and it booms everybody out, and other times it's not close enough and it's not picking up. So is that close enough?
That's good.
Okay. My name is Brent Chicken. I'm with Steptoe and Johnson, PLLC. We represent Javelin Energy Management Partners and Javelin Uinta, which I'll refer to collectively as Javelin for our short presentation today. These are, Javelin is a successor in interest for Utah assets to EP Energy EMP Company for purposes of today's board hearing on the March 10th order to show cause, which addresses the annual reporting and sunset requirements in various pilot orders, or pilot program orders, I should say, issued by the board concerning multiple horizontal well development in the Uinta Basin specifically. Javelin has 8 pilot program orders issued by the board that would be relevant to the order to show cause. Those are orders 139-151 issued in February 2018, 139-155 issued in July of 2018, 139-157 issued in September of 2018, 139-159 issued in February of 2019, and lastly, orders 130-02 through 130-05, and all of those were issued in December of 2020. I think it's safe to say that based on that Javelin, and in part through its predecessor in interest, has been the proverbial ground zero in terms of the board's horizontal well pilot program orders since late 2017. I think they're kind of uniquely situated to provide the board with insight into the horizontal well development of the basin pursuant to those pilot program orders. And so along those lines, with me here today is Daniel Brooks. He's Javelin's land manager, Utah, and community liaison. He's traveled here today to provide the board and the division with Javelin's responses to the order to show cause to the specific items. Those items being, is there justifiable reason to continue pilot program orders, annual reporting, any factual or legal impediments to rendering pilot program orders with their sunset provisions, as the chairman mentioned, into permanent orders, whether there's any objections to those concepts, or whether either of those concepts would create negative or prejudicial effects. But the board's motion, or I should say the board's order, also asks affected operators to come forth and answer questions if the board has any, provide a summary of important information and processes gleaned from the pilot program orders, and inform the board or the division of any other emerging issues regarding horizontal well drilling and fracking in Utah. I think what the board's going to find from Mr. Brooks' short presentation and testimony is that the board's pilot program was not only quite visionary in the sense that the board really carefully listened to and approved a horizontal development plan for the Uinta Basin that actively adopted really the best parts of the horizontal well development concepts from various other Rocky Mountain states. And it also resulted in a development scenario that really does a very good job of protecting correlative rights, preventing waste, minimizing surface disturbance, and maximizing resource recovery, pretty much as good or better than any other state in the Rocky Mountain region. And so, you know, with that short introduction, I'd like to turn the mic over to Mr. Brooks, and we'll go through his short presentation, unless the board has any specific questions at this time.
Any questions, board? Please proceed.
All right. Well, good afternoon, board and the division. Thank you for your time and consideration. I will say, as Brent mentioned, I'm Dan Brooks. I'm our Utah land manager and community liaison. It's exciting to be here. It seems like just yesterday we were in Delta, Utah, 5 years ago, presenting before the board on, at that time, our predecessor's first horizontal spacing. So with that, I'll get going. A little fun fact here on that first slide. What you don't see is my son, my 4-year-old's monster truck in the immediate foreground that I took for him. But I thought I'd crop that out for this. So, hi to my boys back home real quick. So I'm going to just jump in. I'm really going to touch on 3 points today. Just a brief introduction. This is the first time sitting before the board and the division as Javelin Energy Partners. So just a real brief who we are as Javelin. And then walk through our support for the cessation of annual reporting requirements and then our support for making these pilot orders permanent. Go ahead. So a lot of words on this slide and pictures here, but what I really wanted to get at, a couple things. First and foremost, we are Javelin Energy Partners. We are the operator. We hold the leasehold. We are operating out in the basin. Our parent company is Crescent Energy, who is a public company located in Houston, Texas. So that's our parent, and then we do, if you want to liken that to kind of our brother and sister companies, Contango and Crescent Mineral Partners all fall within the Javelin family. Really when I glean and what I read from this and what's important to us as Javelin is we stand for doing the right thing the right way. That's building partnerships with not only, well, with all of our stakeholders, our community, partners, just doing the right things right, safety, environmental, and the like. We hold integrity, trust, accountability, teamwork, and excellence in high regard as well. So with that, I'll jump right in there. First and foremost, as our support of the cessation of annual reporting requirements, as Brent mentioned, we've reported on 8 different orders from 2018 to 2023. Specifically, the 7 orders there that are below, and then the 139, 151, which we also reported on as part of one of our 130 series, basically revisions. Brent touched on these, and I just wanted to make a mention. I talk about the big 3 with our team a lot, which are protecting correlative rights, maximizing resource recovery, and minimizing waste. So really all of this is through that big 3 lens. So we do, and as Brent kind of touched on, we do it was the right thing to do on these pilot orders to report annually. What we're doing, how we're doing it, what we're seeing, and what we can improve or tweak. And quite frankly, I think we've done that, and it's been a great process. We came back a couple times to reduce some setbacks, improve how we're doing those big 3, and as such, we're fully supportive of the cessation of annual reporting. Now moving into our support for making these pilot orders permanent. As our development over the last, well, from 2018 forward, as we reported this most previous annual report, we have over 85 wells, horizontal wells producing, over 14 million barrels of oil, 32 BCF of gas, some associated water there, as you can see. But again, all of that has been seen through the lens of the big 3 And of course, our lands cover fee, tribal, state, federal, so it's a good mix there. Also, in our support for making these pilot orders permanent, it provides for a couple things or a couple items. It allows Javelin and other operators here in the room to collectively look at refining these on a larger scale, larger scope, rather than just pilot orders that are in numerous different pilot orders. So helps to provide for potential consolidation or discussion of field-wide type larger scale orders. And then also really allows us as operators to understand the rules that we're playing by, long-term development, capital expenditures, planning, and the like. So with that, that's all I had today. Again, we're supportive of, one, happy and proud to be here. Thank you again for your time and consideration. We support cessation of annual reporting and then making these pilot orders permanent. So with that, thank you.
Anything else, Mr. Chicken? On your
No, we don't have anything else. I think the shortness of the presentation indicates that this has been this plays a really important role in how Javelin Energy has been conducting its development in the basin for many years, and so this seems like the next logical step to take, but either myself or Mr. Brooks is happy to answer any questions the board might have.
Quick question, are there any new emerging issues that you see in the basin related to horizontal drilling and production in general?
I can tell you about one emerging issue that I've addressed with counsel for the board. I can't tell you I have a ton of boots on the ground information about it, but there is a growing understanding that some of the more widespread and prolific midstream operators in the basin are planning some rather substantial maintenance operations this summer, and our understanding is that that might be impactful to many different operators, and I'm hoping other council or operators that are here today might be able to comment as well on whether they're hearing that. But my conversations with board counsel on that issue has really been limited to we think this is coming down the pike. We should probably get on top of it before there's large-scale curtailment and things like that might have to be put in place to for operators to remain in compliance with the board's flaring and gas handling rules. So I wish I had, specifics I could give to you, but this is just kind of, through the grapevine, we're learning that, one or more midstream companies are saying, hey, it's been a long time since we've maintained this and replaced these sections of pipe, and I think it's basic stuff, replacing cathodic protections and things like that. But as we all know, you got to dig up pipe to do that, and if the pipe's dug up, it isn't carrying gas away from wells, and if it's not doing that, then you have flaring problems because we have, as the board knows, there's flaring limitations once you get past that initial drilling and testing phase, and while you can we can come back to the board when it's happening with requests for agency action for, variances and exceptions to the flaring rules. I think really are, my idea of talking to Mr. Begley about it was just, really saying, hey, if this happens, we might, you might be getting a lot of requests from a lot of people all at the same time because we don't have that many midstream companies operating in the basin at large levels.
Well, thank you. That actually is a concern, and I appreciate that. And if any of the others that are going to speak before the board here in the next couple of minutes have anything to add on that issue, we'd very much like to hear about it as well. Does that complete your discussions for us? Oh, yes, Mr. Moon.
So the new wells that you're drilling right now, are they pretty much all under these newer orders with a 100-foot hill-toe setback, or are you still having to stop at the 330 feet in some cases?
So we have a good mix. Our newer wells, the last couple years have been at the 135 heel and toe, and we may have drilled a couple further north that were 185, but they all have been most recently all the reduced setbacks. Yes, sir.
All right, well, thank you. If that completes your presentation to us, we
does.
appreciate it
Thank you.
very, very much.
Appreciate it. Thank you.
Thanks for coming all this way.
Yes.
Okay. Mr. McDonald?
I was going to say, Mr. Borden, if you wouldn't mind, this is Christian Sizemore from OVINTIV. Again, with his travel schedule, if he could go before, because I've got to be around, so.
Yeah, I know you're trapped here, so, yes, please proceed. We'd love to hear before.
Okay, just make sure this is on, yep. My name's Christian Sizemore. I'm with OVINTIV. I'm the director of the Rockies and the Land Innovations team, and here to speak on the support of both pieces provided here. I think, we've had a lot of pilot orders out there. We have a very interesting position in that we're in the stress swing. And so we have a lot that are stand-up, and then we have a lot that are transitioning to lay down. And you've seen some of these pilots with a recent one, what we call our Elton Black Hair unit, that we're actually switching from what was the pilot order being a stand-up to doing laydowns. And so I think you've seen a lot of that testimony from our staff on the value of what we've learned from those, and are glad with the reporting ending, and kind of you're seeing that in our new orders coming out that where we reduce the setbacks, lease lines. We're trying everything to develop this in the most economical and recovery possible. And so, over this next year, we'll be doing a lot to solidify some of the area that we have a lot of comfort on in stand-ups and laydowns. And then we still have a little bit of learnings that we consistently do. Some of the wells coming online down more towards what was the Greater Monument Butte unit that we'll be trying to understand still kind of that stress swing. And so I think through time you'll see that we'll finish spacing that out over the next couple of years as we collect data, and we plan for that in a lot of our development, spend extra money to try to learn, and then our geologists and engineers come to testify to why we're changing it the way we need to change it. So with that, I guess our support is there for stopping the reporting, and a lot of these we're already kind of replacing with permanent orders. So.
Thank you. Board, any questions for Mr. Sizemore? Mr. Moon.
Just whether you wanted to comment on the gas takeaway.
Yeah, sorry about that. As for the gas takeaway, it's obviously a major concern. As you guys understand, the basin it's either a gas takeaway problem, it's a water takeaway problem, it's a oil takeaway problem. It's a logistical struggle, and we've done a ton of work to try to eliminate that as much as possible. But these things do play a role in it, and obviously we try to plan to not ever flare. So we work through different things. We are lucky in the fact that kind of our southern position is under our own gas takeaway. So we have some relief, but that doesn't guarantee all relief. Hydraulics and everything, we are exposed to other gas takeaway providers, and it's already been a problem, and I think will continue to be a problem. And so knowing that those are out there, and hopefully your support to keep moving the basin forward while we have these issues, because there's just not as many options as you may have in some of the other basins out there.
Thank you. Any other questions?
Just anything we can do as a board or board council to help with that, let us know.
Yeah, we will. I think we're pretty open and honest with you guys and make sure that we come to you if there's any problems. So thank you.
Thank you. Mr. McDonald, are you prepared to speak next.
Yes, thank you, Mr. Chairman. I'm going to, speaking on behalf of, I was asked to respond on behalf of UNOWAX LLC, who is another operator in the basin, as well as myself as a practitioner, who, I appear in front of you all the time. To basically just reiterating the points that were made by Javelin and OVINTIV, the system has worked fine. I think in the way that our procedures work here work the best. In other words, you've had the orders in place, you got some reporting, but at this point, if there's been any information that has come out of the development that's occurred, you find it by modification petitions that are filed to modify the existing orders. So, and you're getting all the information that they've developed to justify, for example, the setback reductions, or having, at this point now, the appropriateness of drilling unit boundary wells. So the process that we have in place is working just fine. And there's no need to either continue trying reporting on this, or to, what really should happen is to make the existing orders permanent, and then as modifications are proven up by the data and development, the operators will come in front of you and ask for the modifications that are justified by that data that they collect. And that's all we have.
Thank you. Mr. Mayo, huh? Oh, yes, we're going to ask the same question of you on pipeline capacities and things of that sort.
Oh,
Did I read your
different
mind?
question. Horizontal rulemaking, do we need to do more horizontal rulemaking, or is everything
Well,
headed the right way? And
I think the caution I would have is what's happening in the Uinta Basin isn't necessarily what's happening with the Paradox Basin. So I think there is some rulemaking that we initiated where, the discussions between UPA and its members and the division were that these have to be very limited in nature in a general form, but to provide for some more flexibility. For example, right now, you're stuck by sectional drilling units, and you can only drill one well, and you have to be 660 off the basis. Some of the ideas that were being kicked around were you can drill as long a lateral as you want, as long as everybody in the pathway is notified so that they know what's happening. As far as the how many wells you can drill instead of just being one before having to come in front of the board, you may have the flexibility to drill up to 2 or 3 of those at that time. And those are general rules that can be applied statewide, as opposed to saying, well, it should be a 100-foot setback. Well, that may be appropriate in the Uinta Basin, but it wouldn't be appropriate in the Paradox. So that, just to let the board know that, yes, there should be some horizontal rules. It should be very limited, though, and through the request for agency action process, you can deal with it on a field or a particular play based on the geology and reservoir characteristics at that time.
Thank you. Mr. Mayo?
Thank you. I represent a handful of operators and non-operators at times here before the board. When I received the order to show cause, I passed it on to my clients and said, let me know if you have cause why these shouldn't. And obviously none of them did. So I don't have any particular operators here to argue in support of this, because the purpose of this hearing, as I see it, is to argue against permanentizing these. I think it makes a lot of sense. No reason for me to repeat it here today. Same with gas takeaway issues. It's a concern, but each operator is navigating it the best they can, and I don't know for sure, and I certainly don't have any proposals from an operator to provide to you today as to specific steps the board or division can take to help address that. I think it's just a growing pain that's going to resolve, but there may be a time when that comes up that the board can be useful in moving seismic forces. And on the horizontal wells, I think Mr. McDonald said it exactly right. I think it does feel a tad repetitive coming in here and seeing the same data for the same requests for the same setbacks over and over again. And I would imagine there's some way to set up field rules that would help alleviate some of that, both pressure on the board and help owners get only information that they actually need to respond to. If you're a mineral owner and you get 3 spacing requests in a month, that's a lot to process. If they're all matter of fact, maybe you have more time to address the things that really are important. So that would be it. And absent any questions, I'll be quiet.
Any questions for Mr. Mayo? No? Last but not least, Mr. Hunter.
Thank you, Mr. Chairman. I just wanted to comment briefly on the horizontal statements. I agree with Mr. McDonald, Mr. Mayo. I believe a field-wide spacing regime is appropriate, especially given the different geological characteristics in Utah. So if you have one set of orders come forth, whether it's a request for agency action or if the board takes up regulatory a matter itself and actually writes a regulation that says within this geographical boundary we will have these setbacks and these characteristics. As Mr. Mayo said, it would provide some certainty for both operators and mineral owners. If you're already spaced, you know who your neighbors are and you know who you're going to be in a well with. And knowing that ahead of time will definitely cut down on the amount of information processing that has to be done when you get that notice with the stratigraphic definitions and the legal descriptions and so on. So I agree that horizontal rulemaking is probably a good idea, narrowly tailored to individual areas.
Thank you very much. Would anybody else like to speak on these issues before we move to the next item?
Mr. Chairman, Bart Kettle, Deputy Director with the Oil and Gas Program. I'm just going to speak real briefly that from the program's perspective, we don't find a need to continue annual reporting. We find that as new information comes forward, operators bring it in their spacing request to the division.
Thank you very much. That's good insight from the division's perspective. Anybody else wish to speak on the pilot orders issues, or any other questions from the board for anyone that's still in the room? Oh, is there anyone online that wants to comment? No? All right, well, thank you very much. I feel like we had an all-star team brought together here today to have all of you in the room at the same time. Do we need to step out to discuss what we've just heard as a board? I know you don't want to, but I want to.
Okay.
So we're going to step out briefly. Thank you. Sorry for that delay. We did want to talk about this important issue, at least briefly. And, we are back on the record in case I neglected to say that we were off the record, but we are on the record again. I would like to call for a motion related to these pilot projects.
Mr. Chairman, I'd like to move to end the pilot project annual reporting requirements effective today, March 22nd, 2023. We'd like to make any orders with sunset provisions permanent. And third, we request that the companies work with our board counsel in identifying any orders that might be affected by this so that we're sure to be inclusive of everything. So if you just get a hold of our board counsel. Thank you.
Any last comments from the board before we vote? All those in favor say aye. 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 Let the record show that was unanimous. Thank you very much again for your time and coming out to speak with us about this issue. I guess we are now on to the last item of the day. Previous item number 3, now number 4. Docket number 2023-012, cause number 132-14, in the matter of the request for agency action of OVINTIV USA, Inc. for an order pooling interest, including the compulsory pooling of the interests of certain consenting and non-consenting owners in the LaPrade, Utah 1-12-4-4-1-2-1H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Formations. I'd now ask for appearance of counsel.
Fred McDonald of counsel with Lear & Lear on behalf of petitioner OVINTIV USA, Inc.
And Anthony Hunter on behalf of International Petroleum, LLC.
Elizabeth Harris on behalf of the Division of Oil, Gas, and Mining.
Thank you. Over to you, Mr. McDonald.
Mr. Chairman?
Yes.
I also need to disclose that my family has a least interest in this well. And likewise, I'll participate in the conversation, but won't be voting.
Thank you very much, Mr. Moon. Now we're make sure there's no objections. Are there any objections to him participating but not voting in these proceedings?
None from the petitioner.
No objection.
No objection.
Thank you. Thank you. Please proceed, Mr. McDonald.
Chairman Borden, on a couple of procedural matters. First and foremost, I would like to get the stipulation from the division that they are not objecting to the legality of the notice of opportunities to participate in this particular cause.
And given the board's ruling in the prior matter, the division has no objection to the notice.
Thank you. Is that sufficient, Mr.?
That's on the record. Secondly, I'm going to object for the record to Mr. Hunter's participation, given the fact that he has acknowledged that his client is not participating today, and on the fact that he failed to respond to the pending motion for partial summary judgment, and that motion needs to be decided to start.
One moment, please. Mr. Hunter, would you like to respond to Mr. McDonald on his last statement?
Yes, Mr. Chairman. International Petroleum, LLC is a party respondent to this matter. We filed our response to agency action in a timely manner on March the 2nd. Deadline, as Mr. McDonald pointed out in a previous hearing here today, the response deadline for this calendar date was March 8th. So we are a party to the case. The motion for summary judgment is a motion, and according to the rules, I can respond to that orally at the hearing. A written motion would be appropriate if I filed a separate motion for you to consider out of time, but I don't have a written response to the motion. I will be responding orally today.
McDonald.
Yes, as far as that goes, his oral motion has to be shown for good cause after the filing deadline. And again, the motion for summary judgment was filed. The time period for response to that passed under the rules of civil procedure, which are adopted into the board's rules. So, and the issue, as I understand it from Mr. Hunter, relates to mootness, which is a legal issue. And his reasoning for his client circumstances doesn't answer the question as to why Mr. Hunter couldn't respond to the legal argument of mootness.
I have a clarification on that.
Yes, Mr. Hunter.
Just pulling on my notes. Stand by. So, Rule R641-105-300 entitled Motions. All motions or responses to motions available to petitioner or respondent at the time or his or her request for agency action or response is filed will be filed and served with the petition or response provided in additional rules. So Mr. McDonald's motion should have been filed with his request for agency action. That's the preference in the rules. Further down in the same rule, oral responses and written responses to motions may be presented or filed at or before the hearing. There's no good cause requirement in that rule. And so I'm responding to Mr. McDonald's subsequent motion orally here at the hearing today. However, if the board would like me to make a good cause argument, I'd be happy to.
Division, do you have any comments on our present situation?
We did not file a response to this motion. I think this is something that the division doesn't have a strong preference in one way or the other. I will say, reading the rule, it does appear that Mr. Hunter has read it correctly. Oral responses to motions may be presented or filed at or before the hearing. I don't see a requirement that a written response has to have been filed. If you want me to take a minute, I can track down where the civil procedure rules are incorporated and come up with an opinion as to whether the civil procedure rules would trump this rule, but my initial gut reaction would be probably the procedural rule of the board governs.
Thank you. You need not do that. But I do want to confer with board counsel for a moment.
Mike Begley, counsel to the board. Chairman Borden and the rest of the board members, I need to let you know that we had a preliminary conference call on this yesterday, and that was determined and agreed to by council is we would take this as kind of a phased approach because there's multiple procedural issues and then a substantive one. And so what was agreed to by council is we would tackle the mootness issue first, let all the parties that want to argue and be heard on that issue, and then with the reserve ruling on that, and then go into the merits of the motion for partial summary judgment, and go through that, and then to the remainder of the merits of Mr. McDonald's client's RAA after that. That's kind of the approach that we agreed to yesterday over the phone. So I believe that would probably be the best, most advantageous kind of way to proceed one step at a time.
That sounds reasonable to me as well. So, Mr. McDonald, do you have anything more on this issue of mootness?
Yes, and the fact is, it goes into the issue of Mr. Hunter's and his client's response while stating that they don't have a defense and that they're not going to present any evidence and that they agree to allow the board to adopt the joint operating agreement. He also continues to sustain his objection that about the terms of the JOA that are included, And because of that particular reasoning, that's why we filed the motion for summary judgment. And under the rules of procedure is that the way that you're supposed to respond to that, otherwise it's adopted as a matter of law. And our argument is set forth in the brief that the rule says that if you file an objection and there's no board request for agency action for compulsory pooling filed within 60 days after receipt of that, then the board is to adopt the joint operating agreement of the party as a matter of law. And so we believe that that issue is still pending. It needs to be ruled on. There's several matters that are going to come up with the same situation, same factual situation. And because of the factual situation here, it's appropriate for the board to rule on that partial summary judgment. And it's not moot because of the way that it was responded to or lack of response to the partial summary judgment by International Petroleum.
Mr. Hunter, any response to that?
Yes, thank you, Mr. Chairman. We need to make sure we're dissecting things appropriately here. Mr. McDonald did start to go into the merits portion a little bit, but we need to keep a tight focus on just the mootness part. The legal definition of mootness is if the requested judicial relief cannot affect the rights of the litigants, the case is moot, and a court, the analogy here being the board, will normally refrain from adjudicating it on the merits. That's the legal standard for mootness, according to the Utah Supreme Court. So our response, it included two requests for relief. One, dismiss the motion for partial summary judgment as moot, because there's no live case or controversy here anymore. Because as Mr. McDonald stated, we're not here to oppose the imposition of the JOA. That's not our purpose here today. The second point is that the second relief requested asked for the board to impose a just and reasonable JOA. That's just what the law says. That's just what the statute requires. I only asked for the relief that we're entitled to get under the operation of the statute. So, in a way, that request is also moot, because I can't affect that won't affect the outcome in front of the litigants, because you have to impose a just and reasonable order in the first place. But the reason that I had to respond is because Mr. McDonald filed his motion on March the 1st. My client hadn't intended on responding to this request for agency action at all, hadn't intended contesting it at all, until Mr. McDonald filed that motion for summary judgment on the 1st, to which I responded the next day on the 2nd. That's moot. There is no live case or controversy. We're not arguing about the validity of paragraph K, Article 16K here today. It's not what we're doing. And Mr. McDonald makes an allusion to what's called the public interest exception to the mootness rule. There are three parts to that exception. The first part is it affects the public's interest. Well, yeah, okay, I think I'll concede that. There is a public interest in having regulatory clarification. The second branch is it's likely to reoccur. I'll concede that too, happily. Yes, this definitely will come up again. I'm virtually certain to it. But then there's the third hurdle, and that is because of the brief time that any one litigant is affected, it's likely to evade review. Some of these wells have been producing for more than a year, sometimes years. There's no particular urgency to figure this out. And remember that these are pooling requests based off of elections that were sent after the well had been drilled and was in production. There's no rush. There's no time factor here. The operator controls that pace. It's up to them. Just for an analogy, the Supreme Court of Utah provides some examples of things that fall under that short time period exception. There are things like election matters, closed political meetings, bar admissions, and abortion cases. I don't think that this qualifies as anywhere near one of those type of exceptions. So Mr. McDonald's argument for a public interest exception fails on its face. So the final point I'd like to make is that there is a vehicle for Mr. McDonald to get the relief he actually wants. It's just not this one. It's not a motion for summary judgment, which you have to kind of backdoor in through the adoption of the rules of civil procedure. There's an actual board regulation covering what's called a declaratory judgment. Normally, courts and boards don't give what are called advisory opinions, and you just almost stepped in that just a little while ago, where you made a ruling, you had a vote, issued an order, but some additional information was requested by counsel for the petitioner. And I think the board was rightly hesitant to give that because that's not the board's place. That wasn't the matter, the case or controversy that was in front of you today. That's a case for a different day. So the declaratory judgment rule, and bear with me while I pull that up. R641-111-100. Any person may, by a request for agency action filed in accordance with these rules, petition the board for a declaratory ruling on the applicability of any statute, rule, regulation, or order to the operations or activities of that person. The petition will include the questions and answers sought and reasons in support of or in opposition to the applicability of the statute, rule, or regulation involved. So that's exactly what Fred needs today. Mr. McDonald needs an answer. Does this regulation apply to this situation? He can get a generic answer by asking for it this way. And there's even a roadmap for the board to follow. In -200, the board will consider the petition and will notify the person that no declaratory ruling will be issued, or issue a non-binding declaratory ruling saying, this is what we think, these are how we feel, this is our preference, this is our idea. Or they can decide that a binding declaratory ruling affecting the petitioner or any other person might be proper and initiate a proceeding under R641-104, the notice of agency action rules, which will be conducted according under those rules. So there's a way for Mr. McDonald and OVINTIV to get the answer they want. It's just not this way. And there's a reason why it's not this way. It's because right now it's moot. We've already agreed that we're not going to object to the imposition of it. So Fred doesn't need, Mr. McDonald doesn't need, I apologize for my familiarity with Mr. McDonald, but Mr. McDonald does not need an answer on whether the 60-day rule applies today, because we're not arguing it. There's no relief that this board can grant that's going to change that, because we're not here to fight that today. And with that, I'll turn the mic back over to the board, or to Mr. McDonald.
Back to division.
Fred.
Oh, sorry. Mr. McDonald.
That's fine, Mr. Chairman. Thank you. I think the division's being Switzerland in this one. Mr. Hunter is trying to have it both ways. The response indicates he wants to challenge us and all this, and now he's saying, no, it's moot. And it's not moot. Based on the facts of this situation and the application of the board's rules that say if you file an objection and there's no request for agency action filed within 60 days to enforce that objection, then the board adopts a JOA proposed by the operator as a matter of law. The facts of this circumstance were exactly that situation. You can't necessarily get a declaratory relief because it all depends on whether or not the party filed an objection and then failed to respond in 60 days. And to try and eliminate that 60-day argument is to render it moot, because then you would never have any time that would require to come forward with a compulsory pooling action to enforce your objection. As far as the public interest goes, that's exactly why this goes forward with it. If Mr. Hunter thought it was moot when he got the motion for summary judgment, he should have responded to it by providing what he's trying to say now. But under the rules, he didn't do that. We provided that. We explained why it was still pending. He didn't respond within the time period. We filed a reply memorandum saying that he didn't do it. And under the rules of civil procedure, if there is no response to a summary judgment, it's adopted. So that's the answers with this, is that the board should rule on this based on the facts that were outlined in the partial summary judgment, that Mr. Hunter's client filed an objection back in January and never initiated a board action as required within 60 days after that receipt of that document to enforce his objections. And that's a proper ruling. That is not being moot. Thank you.
Division, huh?
Well, this really is a legal issue. I have checked with my client, and they have no opinion on it. So I could give you my opinion for whatever it's worth, which probably isn't much. And I don't know that I have an opinion on the mootness or not mootness. I will say, from the division's perspective, I think if the board determines that the motion is not moot and actually issues a ruling on it, the division does think that the underlying issue is an important issue that needs to be looked at and understood because it does affect a lot of parties. And so it would prefer that there were not binding precedent being made on a default. So I guess the division would ask if the board does determine that it's not moot, that it limit its ruling to this particular case, so that the issue can actually be looked at and briefed and dealt with.
Thank you. I'm going to request we go off the record and go into consultation briefly because I'm a geologist. And we are off the record. Thank you for allowing us to consult. It was very helpful. And we've decided that we are reserving a decision on the mootness issue. Please proceed on the motion for partial summary judgment. And it is over to you, Mr. McDonald.
Well, some of it's the exact same argument from the standpoint of the mootness. The situation is you have, based on the filings that were made, are affidavits stating, and first of all, to understand that International Petroleum is a consenting owner in this situation. They're not disputing that they're a consenting owner. They filed objections to the proposed joint operating agreement back in January and never filed anything after that as far as initiating the board action under 649-2-8A sub 4. OVINTIV did capitulate to all of the objections except for one article and agreed to that. But again, as the motion for summary judgment outlines, that's what the rule is intended to do. It's not just the operator that has to initiate actions here. And if you go back in the rulemaking process, and I cited where it was in some of the hearings that went on, the idea was that if it's also incumbent upon a party that's objecting to the terms of the joint operating agreement, that if they want to enforce it, they need to take action, and it can be limited just to that one issue. That's the point of the rule. And in this case, Mr. Hunter's clients did not do anything, and here we are now in February with the filing of the request for agency action, and now we're, again, it was going to be a fighting about it. Now, again, the situation of the mootness is the question here, is there was never any response to the partial summary judgment. So based on the facts that are submitted to you that are uncontroverted, application of the 60-day rule requires adoption of OVINTIV's joint operating agreement with the capitulated changes as a matter of law, because his client did not file a board action to enforce its objections within 60 days after receipt of those objections. Thank you.
Mr. Hunter.
Beg the board's indulgence for just one moment as I review Mr. McDonald's request for agency action. Just need to find a page number. 1 second.
Mr. Chairman, as a point of,
I appreciate your indulgence.
Mr. Hunter, if you could give me a second here. Is the board ruling that Mr. Hunter can participate in a discussion about the partial summary judgment motion?
Yes.
It's overruling my objection to that.
That was overruled, yes.
Thank you, Mr. Chairman. Just to start with, Mr. McDonald mentioned the word capitulate twice. And as you may notice from a careful reading of his request for agency action, there are 2 exhibits. One is Exhibit 1, and I believe the other is Exhibit 2. The first exhibit is the JOA that will be imposed upon everyone who's not International Petroleum LLC. The second exhibit is the one that will be imposed on International Petroleum. The difference, of course, being the capitulation that OVINTIV states that they've done. The capitulations that we achieved through negotiation and through the first part of the process and the regulation by filing our objection letter were required by the regulation itself. One of the regulations in the modifications that we did back in 2020 was if paragraph 7 in the original JOA, the Form 2015 JOA, will control. It's the default. So if there's modifications or changes or amendments that alter what Article 7 in the 2015 AAPL Form 610, we're entitled to those. And that's what we got. So it really wasn't a capitulation. It was just an acknowledgement of the fact that the regs govern this, and They had to give it to us, and so they did. The second part that I want to address right off the bat with Mr. McDonald before we get to my case in chief is we didn't do anything. Well, according to Mr. McDonald's own affidavits that he submitted from his clients, there were subsequent negotiations the entire time. The whole time, there was still discussion about the JOAs and some other business dealings. Now, I don't believe the affidavit talked about other business dealings, so that's my say-so. But the affidavits themselves talk about subsequent negotiations on these JOAs past the 60-day deadline. So we were still talking. It's not that we weren't doing anything, it's just that we were doing it unofficially. To get into the case in chief for this, Mr. McDonald starts off very boldly and says this is what the rule does and says this is the way it's supposed to be interpreted. I have a slightly different perspective. The main thrust of Mr. McDonald's argument is that it is a mandatory duty on the part of a non-operator to file an objection with the board, a request for agency action on this narrow scope. Does this contractual provision meet the standard of just and reasonable and otherwise comport with the board's authority granted under the pooling statute? Mr. McDonald made a reference to R649-2-8A sub 4, starting off at 4.1. The operator has filed a request for agency action for compulsory pooling of owners in the well and associated drilling well unit. Either the owner or the operator may move the board to determine the reasonableness of the costs charged and the terms of the JOA between the owner and operator as part of the proceeding. So if and when there's a pooling procedure, the objecting non-operator can come before the board and say, we don't like this provision, please rule on this for us. May. 4.2, if no request for agency action has been filed for the compulsory pooling of owners in the well and associated drilling unit, then either the owner or the operator may file a request for agency action within 60 days of the receipt by the operator of the owner's written objection. Again, it's a permissive standard, not a mandatory one. If it was meant to be mandatory, it would have been shall. Now, you can look at legislative history all day long, but I think you also heard earlier from Ms. Harris in the division that you start with the plain language of the regulation. And the plain language here is may. It's optional. It's alternative. Moving on, 4.3, if neither subsection 4.1 or 4.2 timely occurs, then the actual costs incurred shall be deemed by the board as just and reasonable, and the terms of the JOA as proposed by the operator in the notice shall be deemed to govern. I'm paraphrasing the end there for brevity. Timely occurrence of 4.2 is 60 days after the operator receives the written objection. So if you want your contract piece to be heard separately, do it within 60 days. If you want your contract piece to be heard at the pooling hearing, then show up at the pooling hearing. If you don't show up at the pooling hearing, and if you don't file your objection within 60 days, you're out. There's nothing in this regulation that requires the pooling hearing to be live at any particular time, and that's reality here. The pooling hearing happens when the operator wants the pooling hearing to happen. Reality is the pooling hearing comes after the well has been drilled in production for years. If the parties want something done sooner about their contract dispute, they have an option to come here before the board and ask for it, but only if they do it while the problem is hot, while they're in the negotiation, when that election letter has been sent recently. If you want it as a separate request for agency action, adding additional judicial burdens, another docket item here for the board to listen to, do it quick. Do it now. Do it while you're probably paying attention to it. Don't let it sit and linger until the pooling hearing. Or, I guess, if you're happy to let it sit and linger, then just show up at the pooling hearing. The statute, the regulation's construction is permissive, and that comports with another regulation. It's -300 R641-100-300, I think. The rules are to be given a liberal construction. I don't know if I have that cite quite right. but the rules under the board are supposed to be given a liberal construction, a permissive construction. And I think we just heard a little earlier from the division again, we'd like to get this all aired out and get everybody a chance to have hearing. So the structure of the structure in the plain language of the regulation require the board to look at the timeliness of either or. Either you came with the pooling hearing or you did something within 60 days while the negotiations were still live. If you mess up either one of those, well, you're done. But you have the option. The second argument that we have is equitable estoppel. By the affidavit's own admission, subsequent negotiations continued on. If you're going to continue to keep those negotiations alive and then turn around and say, well, they were fruitless anyway because we can just do whatever we want now. Your opportunity to get legal relief on this is past. You know, thanks for playing. That's a pretty perverse incentive to anybody who's trying to negotiate in good faith. If you think you're almost there, if there's a carrot dangling out in front of you, and then it gets taken away, and someone tells you, sorry, no, we talked too long. You don't get to come before the board anymore. Your avenues for legal recourse are closed. That sends the wrong signal to just about everybody. Operators can now string non-operators along and not pay any consequence for that, and impose the original JOA that was objected to and objectionable in the first place. And that goes to my final argument, public policy. If the rules as written are construed in such a way to prevent people from having their day in court, then all the stuff you've heard today about non-locatable owners, confusing AFEs, all that stuff, this is just another pebble on that side of the scale. The rules must be construed to give people their day in court. And any curtailment of that is just a signal to everybody participating that the big guys get their way and there's no chance for the little guys to even have a chance to say what's on their mind. And I'm open for questions at this point. Thank you.
Any questions from the board? Division? Any commentary?
Switzerland does sound nice.
If you can say I don't have anything to say also, if that's what you prefer.
How about this? I did have one. I think that you are again faced with interpretation of the language of a rule. That is the theme for today. And I think Mr. McDonald in his brief told you exactly right. You look to the plain language first. The one thing that struck me as I was listening to argument, I think when I had previously read this rule, I assumed that it was either 4.1 or 4.2. It was one or the other. But as I am just reading that rule, it says and. They can proceed as follows. You can do 4.1 and 4.2, which suggests to me that they are both equal options. So good luck.
Thank you. Mr. McDonald.
Thank you, Mr. Chairman. That's all fine and dandy, what Mr. Hunter said. Obviously, and I'll get into the disagreement with him on the legal issues, but the point is, these are legal issues, and they should have been raised in response to the motion for partial summary judgment, not today. And his reasoning that his client was unable to do that, I sympathize with Mr. Wixom's situation, but that deals with facts. It doesn't deal with the legal arguments he's just trying to present. It's a backdoor way to get in to this situation, okay? And again, if you read the regulation and you go back to the, if you need to, I don't think you need to because the plain language there, but if you go back and look at the transcripts or view the hearings with the rules, The 60 days is there. The whole reason was to make it also the obligation of a party to take action to enforce objections that they have to the JOA if the operator doesn't do a compulsory pooling action. Okay? If you read it like Mr. Hunter is, why have a 60-day rule? Why even have it? Because then it would be whenever a compulsory pooling action is filed, that's when I get to object to it and enforce it. It makes no sense. None whatsoever. This factual situation is exactly why this rule is in place. And Mr. Hunter talks about the little guys. His client's a sophisticated oil and gas operator that has operations out there. They know very good and well what they're doing. And that is the factual situation, uncontroverted factual situation before the board. And it is absolutely appropriate for the board to grant summary judgment, partial summary judgment, because we're not talking about the other owners here. We've got to deal with that later. But as to Mr. Hunter and his client, it's appropriate to rule that OVINTIV's JOA, and we're not even saying the JOA that was originally proposed, we're agreeing to the changes that were agreed in negotiation to be imposed as a matter of law. Now, Mr. Hunter says, well, we're negotiating. Well, I can tell you, when I litigate, and somebody says, I'm going to give you an extension of 14 days to answer, I file something in writing that says that's the case. Otherwise, if I don't get that in writing, I do what the rule says. Mr. Hunter could have easily filed, on behalf of his client, a request for agency action within 60 days after the notice. And then if we continued negotiations, we could have continued that. We could have done any of that. But no, that didn't happen. That was what was required under the regulation, and you have to read it that way. There is no other way that you can read it. There is no other logical way you can read it and harmonize that regulation. So that's why, again, why we believe it's absolutely appropriate under these circumstances to grant the partial summary judgment on the basis of that regulation and rule under the facts that are uncontroverted in this matter that the joint operating agreement as between OVINTIV as operator and International Petroleum should be adopted as a matter of law with the concessions that were made. Thank you.
How many times do I go back and forth?
Would you like to respond, Mr. Hunter?
Just briefly, I think the key here is that the negotiations that were happening during the time between when we filed our objection with OVINTIV up until the request for agency action. I mean, honestly, up until the filing of the motion that requested a ruling as a matter of law on the 60-day issue. From that point to this point, my client considered that still to be negotiation. Litigation wasn't happening until we decided that, no, we don't want this to be ruled on as a matter of law. We weren't going to respond. We weren't going to litigate this until this motion came up. I wasn't even going to be here. Today is my wife's birthday. I wasn't going to be here today. But we had to come in based on a motion that was going to adjudicate as a matter of law our rights. And that's why we responded. And I responded the next day to give Mr. McDonald the notice that we don't have a dog in this particular fight today. You don't need a ruling on the 60-day thing. That's the only reason I'm here. And so for the fact that there's, going back to the mootness, there's not a case or controversy that's still live here, because there is a different reading of the regulation, an ambiguous reading. If you want to go to ambiguity, then we can start talking about, legislative history. But there are two readings that are possible here, and whichever one you decide is the correct one, that's the way this goes. But again, Ms. Harris said this probably should be briefed out in full and given a full declaratory judgment under that separate rule treatment. Because it's not just my client, it's not just Fred's client, but this will affect everybody. This is something where a lot of people might want to weigh in on it because it affects everybody. Everybody needs to know the rules of the road. If I get a JOA, if I get an election letter, I need to tell my client, you got 30 days to object to it, and then you got 60 days to decide if you want to object strongly enough to start an agency action. You can't wait till the pooling hearing. That's not an option. I need to be able to tell somebody very clearly about that. And right now, the way it's written and the way that without guidance in the form of a declaratory judgment action, it's hard to tell. Thank you.
Okay, thank you for your two arguments presented to the board. I'm sure it's all crystal clear to everybody. And what do we need to do, Mr. McDonald, to actually proceed with the request for agency action? It's
If the board wants to hold off on that ruling, that's fine. We can go ahead with dealing with all other parties other than International Petroleum. And that's where my witnesses are ready to go.
We're going to, sorry I'm making this a habit, we're going to go and deliberate briefly, and then I'll get right back to you.
That's fine. We understood, and we understood, you know, the nature of these procedural things today. And as we discussed with council, that's exactly what we expected.
Okay, thank you. All right, we are back on the record, and once again, thank you for your patience. Thank you for my patience, too. I would entertain a motion related to the mootness issue at this time.
Mr. Chairman, I move that the objection to the JOA terms issue is not moot.
I second that motion.
Any comments from the board before we vote? All those in favor say aye. Aye. Let the record show that was unanimous. I would also entertain a motion related to the partial summary judgment issue.
Mr. Chairman, I move to grant the motion for partial summary judgment.
Any comments from the board? In that case, yes. Sorry. In that case, we'll call for a vote. All those in favor say aye.
Aye.
Aye. Let the record show that was unanimous as well. I believe that it's now back to you, Mr. McDonald.
Now we're back, I think, to the regular going forward with everybody else, if you're ready to go.
We are ready.
I trust you. I will get through this as fast as I can.
Thank you. Much appreciated.
All right. Again, appearance for record is Fred McDonald of Counsel with Lear and Lear on behalf of petitioner. Or do you need to read it into the record of the next matter, or are we still on this matter? I guess we're still on this matter.
I read it into the record at the start.
Okay. All right. So
it's a long time ago, but I did.
Okay. Again, Fred McDonald of Counsel with Lear and Lear on behalf of petitioner OVINTIV USA, Inc.
Elizabeth Harris for the Division of Oil, Gas, and Mining.
Members of the board, with me today, appearing virtually from the Woodlands, Texas. Thank you again to the board for allowing them to appear virtually. Are Mr. Jordan Lear, who's the senior land negotiator, and Mr. Kendall Brown, who's the manager of the Uinta Reservoir Engineering. I would ask that they be sworn in at this time.
We'll start with or can I swear them both at the same time? Okay. Gentlemen, do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. I do.
Mr. Chairman and members of the board, the resumes of both witnesses were submitted collectively as Exhibit A in this cause. If separately asked, each would verify the contents of the resume are true and correct. Both have previously been recognized by the board and the hearing examiner appointed by the board as experts in the areas of petroleum land management and petroleum engineering, respectively. Presuming the division has no objection, we would ask that the board again recognize them as experts in those particular fields for purposes of this cause.
Division?
No objection. Thank you.
Board, any concerns? Seeing none, they are recognized as expert witnesses.
Thank you, Mr. Chairman. Also, just to confirm that that I'll be moving for admission of our exhibits at the end of my presentation in chief collectively.
Perfect, thank you.
And also, just want to make sure that you've got the supplement to Exhibit Z that was filed on Monday. That's just the additional receipts showing the receipt of the RAA.
Yes, I do.
Thank you. This cause involves compulsory pooling of the drilling unit established for the Lower Green River-Wasatch production, comprised of the entirety of Sections 1 and 2 of Township 4 South, Range 4 West in Duchesne County. This drilling unit was established by the board in its order entered on August 20th, 2021, in cause number 13007. A true and correct copy of that order was submitted as Exhibit B for this cause. Prior to the entry of the 13007 order, Newfield, which was OVINTIV's predecessor, drilled, and OVINTIV now operates a vertical well located in Section 2. Production from that well has been allocated on a wellbore basis, and there were and currently are no non-consents relating to that well, and consequently no compulsory pooling orders. The 13007 order expressly provides that production allocation from any existing well converts to the two-sectional drilling unit basis effective as of the first day of the month following production of the first long lateral horizontal well. In accordance with the 13007 order, and APDs approved by the Division and the Bureau of Indian Affairs, OVINTIV drilled the LaPrade 1H long lateral horizontal well. It actually has a more proper name, but I'm going to refer to it as the 1H well. Its date of first production was April 16th, 2022, resulting in conversion to the two-sectional drilling unit basis on May 1st, 2022. International Petroleum is the lessee under a Utah Department of Transportation and Division of Forestry, Fire, and State Lands lease covering 0.667358% of the drilling unit. As I mentioned previously, it is a consenting owner, but has refused to execute a joint operating agreement, thereby voluntarily pooling its interest. Under statute, the Division of Forestry, Fire, and State Lands must agree in writing for its lease to be pooled, and consequently, without International Petroleum's interest pooled, the Forestry, Fire, and State Lands UDOT must also be compulsory pooled, or at least agree in writing to pooling once International Petroleum's interest is compulsory pooled. Based on your ruling, they will be compulsory pooled. As alleged in the request for agency action, Border Resources, LLC, is a Colorado corporation and the record lessee of a lease from Weaver 4 Investments. Border was sent and received the requisite notice of opportunity to participate in the well, but did not timely respond. Absent Border's pooling, the interest of Weaver 4, its lessor, also is not pooled. Consequently, OVINTIV will seek compulsory pooling of both interests. However, Weaver 4 will be entitled to its royalty under its lease regardless. Border voluntarily dissolved on January 3rd, 2022, after the notice of opportunity to participate was sent and with confirmed receipt on January 4th, 2022. The request for agency action was sent to and received by David Kenjalo, K-E-N-G-A-L-O, Border's president and shareholder, at his current address in Minnesota as disclosed by the White Page website. As I stated, we therefore seek to declare Border as a non-consenting owner. The board may recall this from a hearing last summer, that Intermountain Resources, Inc. Is a defunct corporation, but it is also a record oil and gas owner. It executed a deed by a purported member of its board of directors and its purported vice president, assigning 70% of the company's interest to the Utah State Treasurer State of Utah Unclaimed Property Fund. However, and if you may recall, there is a serious legal question about the validity of that deed conveyance in the fact that the State Treasurer Unclaimed Property Act cannot hold title to property. It's meant as a collection agency for unclaimed property. It doesn't own the property. It's strictly a fund situation. In abundance of caution, OVINTIV still provided the state treasurer in that capacity a requisite notice of opportunity to lease or participate, but it never timely responded. In addition, pursuant to the board's order, a notice of opportunity to participate relating to the LaPrade well to all unknown shareholders claiming by, through, or under Intermountain Resources was published in the Uinta Basin Standard for 2 consecutive weeks, but no party has responded to that notice or otherwise tenders his or her share of costs. Because Intermountain didn't do this, we're asking that they be declared an unconsenting owner and anybody claiming by, through, or under. However, as was the case with that hearing with the Wolf well last summer, OVINTIV intends to place that money in suspense in accordance with the suspense statute. Furthermore, as identified in the request for agency action, and as Mr. Lear will address in his testimony, there's several parties who were provided and received the requisite notice of opportunity to participate in the LaPrade well, which have also timely failed to respond or otherwise tendered their respective share of costs for the well. As such, they're going to be compulsory pooled as well and declared as non-consenting owners in the well. Finally, some of the fee leases, as you are well aware, were granted by parties claiming by, through, or under the estates of decedents for which there have been no Utah probates or for which have not been completed to properly establish succession from those decedents. As to those parties, again, there was published notice in the Uinta Basin Standard for 2 weeks in accordance with the regulatory requirements. No party has responded to that, and consequently we will ask that they also be compulsory pooled and declared as non-consenting owners. The proof of publication to the parties claiming by, through, and under Intermountain Resources and to the unknowns was submitted as Exhibit O in this cause. As to the non-consenting parties, OVINTIV seeks imposition of a 300% risk compensation award and the terms of a joint operating agreement materially the same as signed by the other working interest owners in this drilling unit, and which terms have been previously deemed just and reasonable by the board and other compulsory pooling hearings. During the recoupment period, the unleased non-consenting owners, that excludes Border and that excludes its lessor Weaver 4, will be entitled to a 17.265299% cost fee royalty representing the average weighted fee royalty in the drilling unit, calculated as of the date of spud of the LaPrade well. The board has jurisdiction over this matter pursuant to Utah Code annotated section 40-6-6.5 and the implementing regulations found at R649-2-8A and R649-2-9A. A certified copy of the request for agency action was mailed certified mail to the known parties sought to be compulsory pooled, including the Department of Transportation and the Department of Forestry, Fire, and State Lands, due to the state ownership in the drilling unit, and mailed regular mail to all other production interest owners within the drilling unit at their last addresses disclosed by the relevant Duchesne County records, and to the Ute Tribe Ute Distribution Corporation and the Bureau of Indian Affairs due to the tribal mineral ownership within the drilling unit. In addition to the published notice of opportunity to participate, which I previously mentioned, notice of the filing of the request for agency action of this hearing was also duly published in the Uinta Basin Standard on March 1st, 2023, the Deseret News on March 3rd, 2023, and in the Salt Lake Tribune on March 15th, 2023. The division elected not to file a response to this request, and as we've stipulated, it has also withdrawn its objection to the legality of the notice of opportunities to participate that were provided. Because none of the alleged remaining non-consenting parties timely filed a response to the request, pursuant to Utah Administrative Code R649-104-150 and R641-108-400, we move to enter an order of default against them and ask that the board grant that at this time.
That order of default's granted.
Thank you. With that, I'll commence my examination of Mr. Lair. Mr. Lair, would you please state your name and business address for the record?
Sure. My name is Jordan Lair, and the business address here is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
Please state your current position with OVINTIV.
I'm a senior land negotiator with responsibility over this drilling unit, among others.
Would you please state for the record the corporate and bonding status of OVINTIV?
Sure. OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of OVINTIV Production Incorporated.
Mr. Lair, I'll direct your attention to what have been marked as Exhibits C through E for purposes of this cause. Do you have those in front of you?
I do.
And were they prepared by you or OVINTIV personnel with your input and review?
Yes, they were.
I'm sorry? Yes, I said.
Yes, they were.
No, hang on a second, Jordan. She's asking me. I asked if they were prepared by him or by OVINTIV personnel with his review and input. Okay, please again answer.
Sure. Yes, they were prepared by me or with my input by other OVINTIV personnel.
All right, turning your attention to what has been marked as Exhibit C, please explain what this shows.
Sure. Exhibit C is just a regional locator plat, and it shows the drilling unit, which is traversed by US 40 and is between Duchesne City to the west and the Bridgeland community to the east.
All right, turning your attention now to Exhibit D, which is shown on the PowerPoint. Would you please explain, there's a lot of information on this, please explain what this shows and its significance.
Sure. This is a plat of the well location and the various oil and gas ownership tracts that comprise the drilling unit. As I said, it shows the general location of the LaPrade well in sections 1 and 2 as it traverses the south half of the drilling unit. As outlined in the RAA pursuant to the 130-07 order and APDs approved by the division and the BIA, the LaPrade well was spud on December 30th, 2021 and completed as a producing oil well with productive intervals within the U.S.M Butte member of the spaced Lower Green River-Wasatch Formation. The date of first production was April 16th, 2022. Although not reflected on this plat, there is an existing vertical, the Ute Tribal 11-2-4-4W well, located in the northeast quarter of the southwest quarter of Section 2. It was drilled prior to the entry of the 130-07 order pursuant to the general well siting rule. and production has been allocated on a wellbore basis under the rule of capture. There were no non-consents in that well, and consequently no applicable compulsory pooling order. Pursuant to the 130-07 order, allocation from the vertical well converts to the DSU basis as of May 1st, 2022. And as noted, there were no remaining recoupments as of the date of conversion. Again, as I said, the plat does show the various oil and gas ownership tracts, of which there are 10 different ones in the DSU. Tracts 3 and 9 are tribally owned, and Tract 5 and 50% of Tract 6B are owned by UDOT and administered by DFFSL.
That represents the Division of Forestry, Fire, and State Lands, correct?
That's correct.
All right, I'd like to point out to the board, as provided in the compulsory pooling statute, royalty under those tribal and state leases are not included in the calculation of the average weighted fee royalty interest applicable to unleased non-consenting owners. Please continue, Mr. Lear.
Yeah, and then to sort of round it off there, the remainder of the tracts shown on the plat are all owned in fee.
Now, turning your attention to what has been marked as Exhibit E, would you please explain what this shows?
Sure, this is a breakdown of the DSU working interest ownership. It's showing that OVINTIV is the majority lessee / working interest owner in the DSU and is the operator of the LaPrée 1H well. Additional lessee / working interest owners in the DSU are U.S.M Uinta LLC, U.S.M Uinta 2 LLC, 4X Resources LLC, Salt Creek Oil and Gas, and International Petroleum LLC. All but International Petroleum LLC have signed JOAs with OVINTIV, the terms of which contractually govern well elections, including the elections made on the LaPrée 1H well. OVINTIV, as the designated operator, has also recorded a pooling declaration pooling the fee leases pursuant to the authorization contained in their various pooling clauses, and intends to further amend that declaration to add in the UDOT DFFSL lease recently acquired. OVINTIV is also in the process of submitting a communitization agreement pooling these leases with the tribal leases, but it currently remains pending approval of the BIA.
Now, turning your attention, what have been marked as Exhibits F through K. These are not PowerPoints because they're a lot of documentation that wouldn't show up on the PowerPoint. Are these official business records of OVINTIV?
Yes, they are.
Okay, and are these the various notice of opportunity to lease and or participate sent for the LaPrée 1H well?
Yes, they are.
Along with proofs of delivery?
That's correct.
Okay. Each notice with the reference attachment reflects compliance with the regulatory requirements of R 649-1-1 and R 649-8-2A. Now, turning your attention to Exhibit F, please outline what it, who it involves and what the interest is.
Sure. Exhibit F is the notice to Border Resources LLC, who, as you referenced at the start of this, is the lessee under a lease from Weaver 4 Investments, covering an undivided 0.326667% interest in tracts 6A and B, which equates to a 0.040772% working interest in the drilling unit. It also shows that receipt was confirmed on January 4th, 2022. No response was ever received from this party, and although the although the lease allows the lessee to pool the lessor's interest, since Border has failed to pool the lease, Weaver 4's interest must also be compulsory pooled. However, it is contractually entitled to the 3/16 royalty under its lease.
Turning your attention now to Exhibit G, which also provides similar information regarding that exhibit.
Correct. It's the notice sent to Kate S. Fowler Markham, who is the apparent owner of an unleased undivided 0.02574% oil and gas interest in tracts 6A and B, which equates to a 0.003214% working interest in the DSU. Additionally, Receipt was confirmed on May 2nd, 2022, and likewise, no response was ever received from this party.
Turning your attention to what has been marked as Exhibit H, again, please provide the same information regarding that exhibit.
Sure, this is the notice sent to Mary Ellen Slimaker Benyon, who is the owner of an unleased, undivided 0.21449% interest in Track 6A and B, which equates to a 0.026771% working interest in the DSU. Receipt was confirmed on May 2nd, 2022, and again, no response was ever received from this party.
Turn your attention to Exhibit I. Again, please explain who it involves and the same information.
This is again another notice sent to Tracy Lee Markham Sherrill, who's the apparent owner claiming through or under the estate of H.B. Markham, Ruth McCormick Markham, and H. Bruce Markham Jr. of an unleased undivided 0.012873% interest in Track 6A and B, which equates to a 0.001607% working interest in the DSU. Receipt was confirmed on May 31st, 2022, and no response was ever received from this party.
Now turning to Exhibit J, again, please explain who it involves and the same information.
Sure, this is the notice sent to Kent Dukes, who's the apparent heir claiming by, through, or under the estates of Harley Bruce Markham Sr., Ruth McCormick Markham, Harley Bruce Markham Jr., and Lillian Mary Moley Markham of an unleased undivided 0.004291% interest in Tracks 6A and 6B, which equates to a 0.000536% working interest in the DSU. Receipt was confirmed on May 20th, 2022, and no response was received from this party.
Finally, turning your attention to Exhibit K, again, please explain who's involved with that and the same type of information.
Sure, as you referenced at the start of this, this is the notice sent to the state treasurer in response to the unknown shareholders of Intermountain Resources. Intermountain Resources owned of record an undivided 3.089472% interest in Tracks 6A and B. In 2017, Jane N. Sheffield and Gordon A. Nebeker, as a member of the board of directors and vice president, respectively, of the company, a dissolved Utah corporation, purported to assign their interest to the Utah State Treasurer, State of Utah Unclaimed Property Fund, as far as 70%, to Jane N. Sheffield individually 10%, Dilworth A. Nebeker individually 10%, and Gordon A. Nebeker 10%. OVINTIV's title examiner has questioned the validity of this deed, especially as to the unclaimed property fund. And the interest of the other grantees is leased or owned by U.S.M Uinta 2 LLC. Exhibit K, as I referenced, is the notice sent to the unclaimed property fund. Receipt was confirmed on May 9th, 2022, and no response was received.
Now turning your attention to Exhibit L, would you please explain what that is?
Sure, that is the survey plat of the LaPrade 1H well sent with each notice.
And that's an official business record of OVINTIV?
Yes, it is.
All right, now turning your attention to Exhibit M, what is that?
It's the AFE sent with each notice, and as Mr. Brown will testify, the AFE was a fairly close estimate of the actual costs incurred in the drilling of the LaPrade 1H well.
And again, that's an official business record prepared by OVINTIV personnel and sent out with the notices?
That is correct.
All right. Please address the situation involving decedents that still own interest of record but have not been, their successors haven't been conclusively determined.
Sure. As you referenced, Mr. McDonald, at the start of this, there are several lessors claiming title in these lands through one or more of the estates of the following deceased record mineral interest owners: Lee Jensen, Sally A. Markham, Anna C. Hunt, Harley Bruce Collins Markham, May W. Cooper, William H. Markham, Mary A. Eves, Lillian May Moley Markham, Betty Ann Hollenbeck, Sally C. Jensen, Mabel Naylor, Harley B. Markham Sr., E. Floyd Ross, Harley Bruce Markham Jr., Nancy Eves Nickera, C. Ed Flandro, Ruth McCormick Markham, Jeffrey J. Noble, Lucille Muir, and Leroy A. Hollenbeck. For all of these parties, either no Utah probate of the estates have been initiated, or if filed, they are incomplete in that there has been no proper distribution made to the heirs or devisees. And although based on heirship affidavits or other inquiries and research done by OVINTIV's lease broker, and except for the specific parties previously identified to be compulsory pooled and declared as non-consenting owners, OVINTIV believes it or the other voluntarily pooled working interest owners have leased all of the successors. However, without an order from a Utah court confirming their succession, the possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore OVINTIV seeks to compulsory pool their interests.
All right, I previously mentioned Exhibit O being in, that's the proof of publication from the Uinta Basin Standard to these unknown parties. Did you ever receive any notice or any response to that published notice?
No, I did not.
And OVINTIV didn't, OVINTIV personnel didn't, is that correct?
That's correct. Neither OVINTIV nor its broker, Lone Wolf Energy, ever received any response to that publication.
All right. Would you please outline for the board a little bit? You had mentioned that OVINTIV had recently acquired a lease on the 50% interest of the of UDOT in Track 6B. Would you kind of outline that a little bit more for the board?
Sure. So there was a lease bid back in January, and as to UDOT and DFFSL's 50% interest in Track 6B, OVINTIV, through its broker, Lone Wolf Energy Incorporated, was the successful bidder for an oil, gas, and associated hydrocarbons lease, but we're still awaiting its issuance at present time. The lease will provide for a 12.5% royalty, and presuming DFFSL has no objection, OVINTIV will pull this lease once issued with the others in the drilling unit, and therefore considers the 50% interest in Track 6B to be voluntarily pooled and not required to be compulsory pooled here.
And as we had previous, when this hearing was called, we had a lot of discussion about International Petroleum's lease. Would you please provide for the record and the board a little bit of information about that lease?
Sure. International Petroleum LLC is the lessee under the State of Utah Oil and Gas and Associated Hydrocarbons lease SLA-798, covering all of Tract 5, which equates to 0.667358% working interest in the DSU. The lease provides for a 12.5% royalty. As we've stated several times at this point, IP is a consenting owner in the LaPrade 1H well, but has refused to execute a JOA and therefore must be compulsory pooled. As a consequence, DFFSL and UDOT as the lessor must also be compulsory pooled, or at least provide its written consent to being pooled once IP is compulsory pooled as required by statute.
I'm now going to direct your attention to what have been marked as Exhibits P and Q. These were also filed as Exhibits 1 and 2 to the request for agency action. Were these prepared by you or OVINTIV personnel?
Yes, they were.
Would you please outline for the board what they are?
Sure. These are the operating agreements that were proposed. They're on a standard form utilized and supplied by the American Association of Petroleum Landmen, which is Form 610. This is the 1989 version with modifications to address horizontal wells. Exhibit B is materially the same Form JOA, sent with all of the mailed notices previously outlined. Exhibit Q additionally reflects OVINTIV's capitulation of all of IAP LLC's objections except for Article 16K. The terms and conditions contained therein, including the modifications made, are consistent with and commonly found in more recently developed horizontal well drilling units including the JOAs signed by other voluntarily pooled working interest owners in this DSU. OVINTIV has prepared identical terms for other drilling units it has operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by UNO-WAX, EP Energy, and other major UNO Basin operators.
All right, I'm not going to show PowerPoints again. This is a very small print, and I don't think it would show up very well anyways. But would you please identify for the board some of the salient provisions that are contained in these joint operating agreements?
Sure. On page 7 of the JOA is the non-consent penalty, which is 100, 300 here. Same as contained in the JOAs signed by U.S.M et al. Within the drilling unit. Further, Exhibit C of the JOA is the COPUS accounting procedure. Again, this is a standard industry form, almost universally utilized and similar to other JOAs in the UNO Basin. Page C3 of the accounting procedure, Article 3B, sets the interest rate at the prime rate as published in the Wall Street Journal plus 3%, which is fair compensation to encourage timely payment of chargeable costs and expenses. On page C9 of the accounting procedure, the overhead charges are outlined with $10,090 being the drilling charge, and then $1,090 being the producing well charge.
All right. I want to point out with International Petroleum's the ruling on the partial summary judgment, there's no longer a dispute over the terms of Exhibit Q to govern the operations as between OVINTIV and International Petroleum. And inherent in that acknowledgement of the terms are just and reasonable for purposes of this cause. Okay, Mr. Lear, is it your expert opinion then that the terms and conditions of the proposed joint operating agreements are fair and reasonable and consistent with those accepted by the other working interest owners in the drilling unit and with those commonly accepted by industry and in particular in the UNO Basin with respect to horizontal well operations?
Yes, it is.
All right. Pointing out again to the board, Utah Code annotated section 40-6-6.5, subparagraphs 6 and 8, provide a compulsory pooled unleased owner is entitled to payment of the average weighted fee landowner's royalty during the payout period or the recoupment period. The tribal and state royalty is not included. Now, Mr. Lair, I'm going to show you what has been marked as Exhibit R. This is a 3-page exhibit. Was this prepared by you?
Yes, it was.
All right. Would you please explain what it shows?
Sure. It reflects the calculation of the average weighted fee landowner's royalty for sections 1 and 2, being the drilling unit as of the date of spud of the LaPrée 1H well. And its summation there is 17.265299%.
Okay, that's slightly different than what's shown on the exhibit. Was there a change in that?
Was there? Sorry,
The exhibit shows 17.7165508%. Is that just a correction that we need to make?
I believe that's a correction we're going to need to make.
Okay. So which one's correct? The 265, isn't that correct? The 17?
I believe the 26. Yes, sir. I believe the 265 is correct.
Mr. Chairman, we will file a corrected exhibit to that effect.
Thank you.
All right. As far as all the other land-related allegations of the request for agency action, can you confirm those for the board?
Yes.
All right. Now I'm going to direct your attention to the certificate of mailing that has been submitted as a pleading that my office prepared and it's already on file in here. Do you have that in front of you?
Yes, I do.
All right. Could you please explain who those parties are and how their addresses were derived?
Sure. Those are the parties that are the affected owners within the DSU. Their addresses were derived from our own internal records, as well as the records of Duchesne County.
Okay. And was that those record searches updated? Did you say?
Yes, that's correct. The record searches were updated for the purposes of this notice list.
All right. Referring the board to what has been marked as Exhibit Z as supplemented. These are true and correct copies of the certified mailing receipts that were returned by my office, confirming receipt of a copy of the request for agency action by the parties to be compulsory pooled or is returned as unclaimed or undeliverable if neither the Postal Service inquiry of the mailing. With that, that concludes my examination of Mr. Lair.
Division, any questions for this witness?
We have no questions for this witness. Thank you.
Board, any questions for this witness? Seeing none, back to you.
Thank you, Mr. Chairman. Now it's my examination of Mr. Brown. Mr. Brown, would you state your business name and business address for the record?
My name is Kendall Brown, and the business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
What is your current position with OVINTIV?
I'm the manager of the Uinta Reservoir Engineering and Development team for OVINTIV.
Turning your attention to what has been marked as Exhibit T for purposes of this cause, was this prepared by you or OVINTIV personnel with your review?
It was.
Would you please explain to the board what it shows?
Exhibit T shows a cumulative amount of capital and lease operating expenses incurred through January of 2023 for the LaPrade 1H. The total of said expenses is $8.5 million roughly. I think one thing worth noting on the AFE versus the data in front of you here on Exhibit T is that although the well came online in April of 22, exact expenses do continue to come in for many, many months after the well is actually put online.
And then is this within reasonable variance of the AFE that was sent out to the parties with the notice to participate?
It is.
All right. Is it your expert opinion then that the costs incurred were fair, reasonable, and necessary, and that the well was deemed economically feasible, as that term is used in the 13007 order to drill?
It is.
All right. Would you please address to the board what are the estimated plugging and abandonment costs for this well?
OVINTIV's estimate for plugging and abandonment costs is $75,000 per well, assuming 100% working interest.
All right, turning your attention to what have been marked as Exhibits U and V for purposes of this cause. Do you recognize these exhibits?
Yes, I do.
And they were prepared by you or OVINTIV personnel with your review and input.
That is correct.
Turning your attention to Exhibit U, would you please explain to the board what this shows and its significance to this hearing?
Exhibit U shows all horizontal wells in the immediate vicinity of the subject LaPrade well. One thing to note on the exhibit here is there are 4 long lateral horizontals shown. The LaPrade was one of a 4-well pad that was all drilled concurrently. The key thing to denote here for this particular location as to its risks is this is in the area that we've testified to the board previously on of where the stress in the basin is changing. So that warrants the change in directions of wells from north-south to east-west. This particular 4-well development, inclusive of the LaPrade, was OVINTIV's very first long lateral development in an east-west direction in the Uinta Basin, which causes some uncertainty as it pertains to well performance with the completions designs that we have. The other thing to note.
I'm sorry, go ahead.
I was going to say the other thing to denote, it's not explicitly shown on this, is more so on the risks here and subsurface risks is relative proximity to the Duchesne fault system, which is just to in and around this area of the Uinta Basin.
Now, turning your attention to Exhibit V, would you just kind of explain to the board each PowerPoint that's shown on here?
Yes. So similar to what I just spoke to, this was OVINTIV's first laydown drilled in the east-west direction of 10K laterals. There can definitely be any sort of offset depletion from vertical wells that have historically produced in these units. The wells that we're talking about today were all Uteland Butte wells, but this pertains to every formation in the Uinta Basin as clay content varies throughout the lateral and throughout the vertical targeting there as well, which can cause significant drilling issues with hole collapse, as well as the drill bit getting stuck. We didn't have any major issues drilling on this particular well, but that risk is always there.
All right, is it your expert opinion then, for those reasons, that a 300% risk assessment award is justified?
It is.
All right, would you also confirm for the record all of the other engineering-related allegations of the request?
Yes.
Mr. Chairman, that concludes my examination of Mr. Brown.
Division, any questions for this witness?
No questions, thank you.
Board, any questions for this witness? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. That concludes our presentation in chief. At this time, I would move for admission of Exhibits A through M,
Okay.
O through R,
Yes.
T through V, and Z as supplemented. We're not going to be submitting exhibits N or S because they are unnecessary given the ruling on international petroleum
Okay.
and the ruling on the summary judgment motion.
All right, exhibits A through V are entered exclusive of S and N.
Correct.
And exhibit Z supplemental.
Correct.
Yes, so entered.
Okay, thank you. With that, we believe, especially in light of the stipulation, that all the statutory and regulatory requirements have been satisfied. The relief is fair, reasonable, and justified under the testimony and evidence that you've received today. And we ask that the request for agency action be approved as conformed to the testimony exhibits presented.
Thank you. Division, it's over to you.
Thank you. The division has reviewed this request and recommends that the board grant the request for compulsory pooling. The one note I would have is there is the unusual ownership interest in that unclaimed property fund. I just would like to remind the board that the last time we saw this interest, there was significant discussion on that, and the proposal that we did arrive at was just to have that held in escrow, which is what is happening here. So the division is supportive of granting the request. Thank you.
Thank you. Board, any questions for the division? No? Seeing none, and you've completed?
Yes, other than to thank the board again for a very long day and appreciate that, and particularly allowing the witnesses to appear virtually from Houston.
Pleasure. Do we need to deliberate, or would someone like to make a motion?
I move that we approve the request for agency action as presented.
I second the motion.
All those in favor say aye. Aye. And anybody have any last comments? No? Seeing none, let the record show that was unanimous. Mr. McDonald, can you prepare the necessary documents?
Certainly. Thank you, Mr. Chairman.
On that point, Mr. Borden, I think that we need to probably work with Mr. McDonald. Maddie and I will have to prepare the portion of that order dealing with the procedural issues that the board, so we'll just work on getting that filed.
I'll be happy to work with council on that.
Yeah, that sounds very reasonable to me. Thank you. I believe that concludes our business for today. Is there a motion to adjourn?
I move we adjourn.
Second.
We are adjourned, and we were off the record.